My lord, this matter may be listed for admission, my lord. This is the IA for condonation of delay, my lord.
Appeal will not come for admission, it will come for orders. If it's IA, is there.
Yes, my lord, for order. May I please, your lordship? Lordship, item number 3. Kindly pass over the matter for day as my senior PK Sharma is unwell, your lord.
Inform the other side.
Yes.
On a request made on behalf of the respondents, matter is adjourned by a week. Item 3, matter appeal. Yes.
May I please, your lordship, mention item number 23 and 24 of the daily list. Thank
Yes.
you.
What is your prayer?
Lordship, the other side has informed me over the telephone that he is in Chennai.
Who's the other side? You're for whom?
Lordship, I'm on behalf of DP Mondal, sir. Lordship.
Lordship, therefore, in respondent.
No, they are for the appellant.
the appellant.
Appellant.
Appellant. And what is the, oh, there's another criminal appeal.
Lordship.
The other side, they are the counsel in the other appeals, they are aware of it? They did
Lordship, there.
on a request made, matter is adjourned by a week.
Lordship.
1 week?
Lord.
1 week.
Highly obliged.
Matters are, to task. 1 week.
May I
Yes,
please, your lordship? Your lordship, victimization item number 13, your lordship. In this
1-3.
matter- 1-3, your lordship.
Yes.
Service repeat is awaited, your.
13.
13 is matrimonial appeal.
Yes, your lordship. Service repeat is awaited,
You
your.
have to check the file. We'll check the file. Be here.
I didn't want.
Appeal.
302. Huh? Admit call for the records. Huh? A Begum, APP. $15. Nava Kumar Kolita, amicus. 6 weeks. Okay.
This is an appeal against conviction, madam.
Yes.
The section 302-201 IPC match. The sentence to life. The section-
Part 3P Kotoki, learned counsel for the appellant with preferred disabled. Admit calls for the records. Miss A Begum, learned APP. Accepts notice on behalf of the state respondent. Okay. 6 weeks, for receipt of records. Here is respond number 29. I issue notice,
Based on the circumstances, there is no eyewitness. They have to report police, man. They have so-called confession.
This the connected appeal has been admitted by Likhiba. Then the application has been filed under so and so. So the connected appeal has been admitted today. Does no issue notice returnable by 6 weeks. A Begum. Okay. By the next date, objections, if any, may be filed. Item 4, amicus. Nurul Hassan.
Paper book is ready, Lord.
None appears for the appellant on call. What about the respond number 2?
Lordship, 322,
Is there any?
37
Here one.
are reflected.
Let's check, Oh. A24. Order dated 5/2 on a penalty order dated 5/2/2025 passed by the learned Lozima Court on the aspect of service of notice upon the respond number 2. Full stop. The service is accordingly deemed to be complete. Full stop. Para. Since the report is of recent origin, the matter is adjourned by 4 weeks to enable the respond number 2 to appear. Full stop. It is made clear that in the event the respond number 2 chooses not to appear, this court would appoint an amicus curiae as the conviction and sentence is under the POCSO Act. Then we'll have for hearing.
Item 5.
Item 5.
The conviction under section 302-34 magistrate.
Paper book is prepared.
Paper book is ready,
You can have this for hearing.
Lordship.
Okay. Paper book is prepared and the matter is ready for hearing. List for hearing in its turn. What about the IA? Are you pressing the IA? You are pressing?
Yes.
Your IA is on the merits or some other grounds?
Merits.
Paper book is ready. You better argue the main appeal. Okay. We are not closing the not its turn. Matter list for hearing on on 3rd of April. Miss A. Begum, learned APP student.
In fact, these matters were fixed for hearing, because your lordship on earlier occasions says that since paper book is ready, so we can hear the appeal.
Yes.
About the conviction under section 302,
Okay.
323, 354, and 385.
All are connected. Same judgment.
Same judgment. And there are 3 appeals, my lord. In one, my lord, I'm leading. In one, Mr. J. Kamar is leading. In one, Mr. Bora is leading. My lord.
Okay.
So, my lord, all the matters earlier also came. So far, Bora's concerned, my lord, he is on bail. He has been granted bail by this honorable court.
Okay.
And we are already.
You tell us the date of your convenience. We'll fix it for hearing.
My lord,
Where is Mr. Kamar?
25th, my lord, of March, your lordship.
After March, they'll be given.
Who is with Mr. Bora? You are with Mr. Bora. And who is with Mr. Kamar? Only for the purpose of having a date of the of your convenience.
7th of April, then. my lord.
7th of April.
Lordship.
Okay. Though these appeals have been listed for orders, it is submitted that the same ought to have been listed for hearing. First up, para. As requested, list for hearing on 7th of April.
Because, my lord, we have already suffered so far the other sentences. Only left with 302.
Mat appeal.
Matter, your lordship.
We had admitted this.
Yes, you have admitted, your lordship. Lordship has fixed the date of hearing, your lordship.
Served. Has it been served?
It has been served.
Neither ID card nor unserved notice, not served. Original case records.
So they have taken step second time also. Second time we have taken step also.
Heard Sri P. Chaudhary, learned counsel for the appellant, also perused the office note dated 6/3/2025, as per which which reflects that the original case records have been received. However, it is also reflected that neither ID card nor unserved notice in respect of the sole respondent has been received. Para?
Yes,
List
that's
this-
two respondents.
Two respondents.
Two respondents.
Yes, on the respondents have been received. Para? Accordingly, list this matter before the learned Lawazima court for passing appropriate orders on the aspect of service of notice, in which the postal track record is also to be ascertained. One is West Bengal, one is Bihar.
Yes.
List immediately thereafter.
Would you like to give a date for law?
Lawazima, we cannot give a date. They'll do it expeditiously.
May I please the lordship, the appeal against my conviction, my lord. Against the judgment and order dated
No,
29.
this has been admitted already.
It's already admitted and steps taken, my lord, to the respondent number 2 by registered post on 22/11.
Registered post, why?
No.
Conviction under POXO Act.
Yes, my lord.
Yes.
20 years, my lord. 20 years.
yes,
and
madam.
40. Don't have.
This appeal was admitted on 1/10/2024, and Miss B.R.A. Sultana, learned legal aid counsel, has submitted that steps were accordingly taken for service of notice upon the respondent number 2. Full stop. Para. On the prayer of Miss A. Begum, matter is adjourned by a week to enable her to obtain the instructions with regard to the service of notice upon the respondent number 2.
May I please, lordship? Lordship, appeal has been already admitted and notice upon respondent number 2 is also served, lordship.
Third.
Lord.
POXO
Lordship.
5/2. We can appoint an amicus, I think. 5/2.
Lord.
Okay. Third, Ms. D. Borpujari, learned legal aid counsel for the appellant, as well as Ms. A. Begum, learned APP Assam. Para. Ms. Borpujari has drawn the attention of this court to the office note dated 5/2/2025, as per which service upon the respondent number 2 has been held to be complete. Full stop. The said report. Office note colon Lawazima court. Office no. 5/2 of the learned Lawazima court. Office note. No. The said report is accepted. Full stop. Para. As the respondent number 2 has not entered appearance and the conviction and sentence involves the POXO Act, we appoint uh, 37. 3 D.K. Buddha learned counsel as amicus to represent respondent number 2. Paperwork prepared.
No,
Records have come.
no.
Records. Since,
Records have come. Records have come.
Since the-
FCR come.
since the records have been received, office to go ahead with the preparation of paperwork. First of, the name of the learned amicus who has been appointed today be reflected in the cause list.
Okay.
List for orders after preparation of the paperwork.
Okay. Just last question with regard to service capacity.
Service is complete, Lordship, because the informant is behind the parlors in some another case also. So just take
9-3.
But-
Poxo.
My lord,
9-3. 9-3 today is.
yesterday, Lordship, that also
Yesterday.
victim did not want to take the
Okay, we'll wait for some time.
my Lordship. We'll have to appoint Lordship. He is neither in pressures he have taken the notice, Lordship, because he is in the
Nonetheless, we'll inform, we'll appoint on the next date. Will not be
Lord-
proper. Okay. Third, Miss H.G. Borwa, learned counsel for the appellant. Para. Miss A. Begum, learned APP Assam, has placed before this court a copy of the WT message received from the concerned police station on the aspect of service of notice upon the respondent number 2. Since the WT message is of recent origin, we adjourn this matter by 3 weeks to enable the respondent number 2 to appear. Full stop. It is, however, made clear that in case the respondent number 2 chooses not to appear, this court would appoint an amicus as the conviction and sentence involves the POXO Act.
Right.
The copy of the WT message along with the enclosure is kept with the records.
my lord. Okay.
Please, Your Lordship. We have
Service-
taken steps, but service report is awaited.
There is a section 5 application,
Yes, sir.
delay condemnation.
Yes, sir.
You said service report is awaited, your steps are defective,
Yes, Your Lordship.
then is it a correct submission?
No, Your Lordship. Otherwise, we may be allowed to take.
That was neither the submission in the mention hours nor now. Don't make this kind of mistakes. If you do not know, then matter is different. Here you have seen it seems that you have seen the report, defective steps, you have not given the notice. Be fair to the court. Send the office note dated 4/3/2025. Para, what is your name?
Yes, sir.
I.H. Laskar, learned counsel for the applicant. Prays for and is granted 2 days time to remove the defects in the steps taken. Para, list after 4 weeks along with fresh service report, along with service report.
Hello.
I take you.
Okay.
May I please, Your Lordship, also we have, we have, as per the office note, my lord, we have taken steps upon the PP to be served to the respondent number. If you
then we will take the information, Lordship, whether it's after.
Ms. H.G. Borwa, learned counsel for the appellant, has submitted that steps were taken pursuant to the order dated 8/1/2025. Para, on the prayer of Ms. A. Begum, learned APP Assam. 2 weeks' time is granted to enable her to obtain instructions with regard to service of notice upon the respondent number 2.
My lord, I have a fear, my lord. My lord, the records have come in this case, my lord, may be permitted to see the record, my lord.
You can see the record.
Okay.
Since the records have already been received, office to go ahead with the preparation of paper book in the meantime.
Okay.
Lordship, the last occasion matter is directed to be placed before large in court. The report is received on 5/2022. As regards service, my lord, it is served on the respondent, your lordship, full respondent. The wife of the petition. They're separated, your lord. Without the people. 5/3/2020.
Not appeared.
No. There are 3 positive orders, your lordship, in favor of my client. She has been habitually flouting this honorable court's order, your lordship.
We have to direct for personal appearance. Heard, Miss B. Bhuyan, Learned Senior Counsel, assisted by your name,
8 alloc.
A. Talukdar for the appellant, for the for the petitioner, who has, for the petitioner, full stop. This petition, for the petitioner, who has drawn the attention of this court to the order dated 5/3/2025 of the Learned Lozima Court, full stop. As per the said order, service upon the sole respondent has been held to be complete, full stop. Upon perusal of the same, this court accepts the said order and service upon the sole respondent is deemed to be complete. Para. Since the respondent has not appeared or shown any cause in this petition alleging contempt, we have no other option but to direct personal appearance of the respondent. Full stop. The petitioner is accordingly required to take steps for such personal appearance within 2 days. Let the next date for personal appearance be fixed on today's
Today's 10.
10th. On 28th,
2/8, your lordship.
28 March.
Can it be on 27? Thursday?
But 28 days is a problem or what?
Leave it alone. Let it be there.
28.
No, lordship, regular process before court process.
The court process.
Fine.
First, we have filed this high for condemnation of delay of 75 days.
First time it has come. What is your name?
Days in full of-
Heard Ms. J. Singh for learned counsel for the applicant who has filed this present application under Section 5 of the Limitation Act 1963 for condemnation of delay of 75 days in preferring the appeal. Full stop. The appeal has been preferred against order judgment so past so issue notice returnable by 6 weeks. Who's with you?
Keep homing.
Sri Miss B. Bhuya, learned APP Assam accepts notice on behalf of the state through her colleague Sri P. Bhumik. Let steps be taken for service of notice upon the respond number 2. Conviction under
302.
by the in the usual process. Steps within 2 days. List of the 6 weeks
Like,
along with service report as well as objections, if any. As well as objections which may be filed in the meantime, if any. As well as objections which may be filed in the meantime, if any. 18 for hearing.
Wait, please, my lord. Lordship, this is an appeal against acquittal. And yes.
Right? Huh? It's
Yet,
We'll have the paper book prepared, okay? Though this appeal was initially placed before the learned single bench, comma, by the order dated 22/10/2024, the same has been placed before us. Full stop. Para. As the paper book has not been prepared, comma, we direct the registry to expeditiously prepare the paper book as the appeal is of the year 2013. Full stop. The appeal may thereafter be listed for hearing. Item 1922. Paper book, paper book. No, two of it.
Small prayer, Lord. Today, Lordship, in this appeal, Lordship, three counts.
We know the CBI matters.
Yes, yes.
Yes.
Let them complete the Lordship. I'll do my part near that. Let them complete.
Ready to move a note of the label.
Now, item number 6.
That's the label.
Please, Lord, before I go into the actual part, I would like to give a brief fact. Basically, decision judgment.
You are in which matter?
My lord, I am in item number 22, Hagenda Chakma.
You're as Borgohai
Yes, my,
for for item number 22.
my lord, 20.
It's a note criminal something 245. No, it's lomba right. Criminal appeal 95.
Yes, my.
Excuse me. Please step on this. Yes.
But what this appeal is prepared against the judgment of the learned trial court of 4/8/2016 under section 120B, under section 120B, 364A, and 302 IPC, life imprisonment without remission. Now, the lordship will, the fact is that on 18th of March 2004, when Azhar was launched by the deceased brother, saying that his brother has been kidnapped by unknown miscreant. They have not mentioned any one of our name. And the investigation could not proceed further. It was registered by the Katichara police station, my lord. And FIR was registered. Now, when the investigation was not moving forward, the deceased daughter and NGO, they filed a PIL before this honorable court. The Honorable High Court, Honorable Division Bench, after looking into the facts, directed that let the inquiry be investigation be conducted by CBI. So after CBI conducted the started the investigation, we were arrested. I will take your lordship to those dates. We were arrested, and it has been alleged by the CBI investigation that confession statements were there. First, second, disclosure statement, and the trial proceeded, and we have been convicted. Now, interesting thing
Confession before the magistrate.
is confession before the magistrate. Confession before the magistrate and implicating each other. That is one aspect. So basically, the learned trial court, when looked into the matter, the prosecution accepted the fact that this entire case is based upon confessional statement of the accused person and to be backed by the disclosure statement, whatever recovered. So what the learned trial court did was that instead of marshalling the evidences, what transpired, the learned trial court did was that the learned trial court proceeded with the first that confession statement to be true. After finding out that the confession statement were voluntary, then the learned trial court looked into other evidence and conviction was, which should be the other way around, because you cannot begin with a confession statement. And that was second. Third is that, your lordship, how the disclosure statements have to be proved. Like, for example, an accused has been arrested under section 27. You need to effect a disclosure statement. Only that part which led to the discovery, that is admissible, my lord. And you have to prove it in the doc that the IO has to recite the exact word that what the accused has said during that. Nothing has been done, my lord. The disclosure statement has not been proved. The IO has not proved the statement. You begin with a confession statement of a co-accused and you record my conviction. And fundamental flaw is that in 313, your lordship, 313, you will ask only the incriminating questions which have come against me in one of the evidences, witness. What the learned trial court did was that 313 also said that your co-accused on such and such date gave a confession statement before a magistrate and has implicated you. What do you have to say? Because 164 statement is not evidence, my lord. Those flaws are there, your lordship. Now kindly come to the FIR, my lord. My lord, I have given one short note like this table, because since the voluminous, the index has been given, my lord.
Just a minute. Paper book is not there. Two volumes of paper books are not there. How many volumes of paper books are there?
Five.
Five.
Five. Five two sets, Lordship, part one and part two. Part altogether 7, Lordship.
My lord, in fact, we are not মানে
এইটো নহয় আৰু এটা আছে পেপাৰ বুকটা আনিব লাগিব নহয় last occasion we have the paper book I think
my lord, there are voluminous of 313 statements. That's why some of these statements very voluminous, my lord. So that means we are concerned with, that's why the Honorable Division Bench asked that you give a tabular form, which accused will be relying on which document.
no those papers are not here নাই তেওঁলোকৰতো আছে আমাৰ এইটো নাই কালি লিষ্ট কৰাই দিয়া চাব দিয়া
কিহৰ বস্তু? একো নহয়, just a table form. কি rely কৰিছে?
আছে সব হৈছে কি কৈছে মই ধৰিব পৰা নাই এইটো লগতে থাকিব ন একেই হ'ব এনে ভাবিলেতো এইটো নাই এইটো নাই এইটো পেপাৰ বনোৱাৰ পিছত একেটা এপিল ফাইল হৈছে নেকি Five volumes, I think.
My
Five
lord.
volumes.
My lord.
7 altogether 7. 7.
আছে বেলেগ কি আছে একেটা আছে একেটা
Because those are exhibit. 313 আৰু exhibit টো বেলেগে থাকে
brother what is the missing in your 94 এইখিনি পৰ্টাৰে মাজতে এটা কাম কৰো এটা কালি মানে ফিক্স কৰো এডভোকেটক কওঁ অকণমান এইখিনি চাই পেলাই ঠিক ঠাক কৰিব দিম brother we'll fix this for tomorrow he's also going to work on the difficulty and we'll ask the advocate and the council to check the paperwork because I think your appeal was registered later slightly yours is 17 and one is of 19
my lord mine one is criminal appeal 95 of 2017
so and one is of 19
my lord
Ranjol the other is also 17 one is 16 why your appeal is not written in the paper book
it has to be because
your appeal is otherwise arises from the same judgment
same judgment your lordship whatever in that matter if I can recollect correctly these matters were listed we have already filed our appeal it was pending so we apprised it was led by on court number 4 I suppose my lord presided by I told that honorable court that my appeal is to be tagged with this matter then this matter was been brought in but paper books and everything were kept separately
Brother, this paper book do it mentions only 3 appeals there are 2 appeals in the court list or arises from the same judgment 95 and 388 So 95 and 388 are not reflected here on the paper book, but they are the same judgment. Suppose 16, 266, 245, and 50. 245, 260, 50. You see the heading of the paper book? 245. Jamal Uddin. Yes, 245, Jamal Uddin. 245. Three paper books, 245.
No, 4, 5, 2.
No, 245, 245, 245. Three.
4, 5, 2, 6, 6.
There are five numbers of volumes. 5 volumes. These are not separate paper books. This is one paper book in 5 volumes. Okay. One. No, it's total 209. 38809.
Not treated to the
Hmm? अच्छा, No, আরো এটা নাই 53 to 66 53 to 66 50 করেছে 50 করেছে 50 ও নাই হ্যাঁ তো প্রথমটা কোডগুলো 53 53 ও নাই ও 50 বেলেগ রাইট 1 2 1 2 3 4 4 out of this 4 3 numbers of 3 have been given 245 266 266 266 50 still this is missing 95 is still missing 95 95 arises from the same judgment. It was filed subsequently, so this paper will also cover 95. Oh, this means because this is one paper within 5 volumes. The April 95 is also against the same judgment. No, different opinions. This is logic or 266. This is which? With 50. Yes, and which is 247. This is 266 again with 50. The mean is 245. 245, 266, and 250. This one is files subsidy. 266, 50. Same. These are separate volumes. These are separate 44. The part 1, part 2, part 3. Yes, different volumes. Except 95.
No, 95 is same.
This will also cover 95. Yes. There are 5 volumes of one paper book. Paper book is one. Since it is thick, there are more than 5 volumes. So it is not for separate cases. It is one case only. And the appeal, there is 4 appeals.
So this paper book for 95 minutes.
No, that's the same book.
Page 1, 2, 41. Page 242. Okay. Okay, so the 242, okay. 242 to 523, 524 to 582. 582. Then 582, 114, okay. Okay. Yes.
Yes, there's some confusion still, but more or less sorted out.
And the last law which I would like to highlight before going to the learned trial court has fundamentally erred that the benefit of remission won't be given to this because they were already behind the bars for almost like 9 years, 8 years. So, which is contrary to the law laid down by the Constitutional Bench judgment in Y. Bhagirat case, that life imprisonment is also a fixed term because you are uncertain. The life is uncertain. So remission will be applicable even for the life convict. What was been laid in the Constitutional Bench judgment, that also been flawed by the learned trial court. Be that so, my lord. Let us go to the FIR.
Life means life, isn't it?
Life imprisonment means life.
Then-
That was in Qatar Singh's case also, it was an issue was that remission, the benevolent provision of remission is applicable only to a fixed term, like 10 years, 12 years. But he said that as far as life is concerned, it won't be applicable. Then it was matter to refer to the larger bench, Y. Bhagirat case, 1985, my lord. The Honorable Appeals Court went to the judgment and found that life itself is very uncertain. Today I am alive. I never know what will happen in under 10 minutes. So you cannot fix that life imprisonment means also is not
So how do you practically bring in the aspect of remission in life sentence?
my lord, after normally conduct of 14 years, 15 years, looking at the conduct that yes, this man has earned the part of remission, let it be gone away. So that was the view,
Let us see.
my lord. In Y. Bhagirat judgment, your
Let us see,
lordship.
yes.
My lord, I have given the book list. 1985. I have got.
Give the citation, please.
My lord, is 1985 to SCC 580. Kindly come to para 12. My lord, today?
Para 12.
Para 12.
Yes.
The two cases before us were referred to a larger bench, larger bench because of the doubt entertained as regards the correctness of the decision in Qatar Singh, especially because of the apparently conflicting view taken by another bench of this court in Sukhalal Hansa versus State of West Bengal. Both of decisions were rendered by a three-judge bench. In Qatar Singh's, persons who were sentenced to life imprisonment challenged an order passed by the government of Haryana denying to them the benefit of the period of under trial detention under section 428 of the code. It was held by this court that the penal code and the criminal procedure codes make a clear distinction between imprisonment for life and imprisonment for a term. And in fact, the two expressions are used in contradictions with each other in one and the same section. The former meaning imprisonment for the remainder of the natural life of the convict, and the latter meaning imprisonment for a definite or fixed period. The court proceeded to hold that an order of remission passed by the appropriate authority merely affects the execution of the sentence passed by the court without interfering with the sentence passed or recorded by the court. Therefore, section 428, which opens with the words where an accused person has on conviction been sentenced to imprisonment for a term, would come into play only in cases where imprisonment for a term is awarded on conviction by a court and not where the sentence imposed upon an accused becomes a sentence for a term by reason of the remission granted by the appropriate authority. Finally, according to the court, the question is not whether the beneficent provision should be extended to life convicts on priority reasoning or equitable consideration, but whether or through construction, the section comprises life convicts within its purview. The court found support to its view in the objects and reasons for introducing section 428 in the code set out in the report of the Joint Committee. Para 13, my lord.
Yes.
We have considered with great care the reasoning upon which the decision in Kartar Singh proceeds with respect. We are unable to agree with the decision. We have already discussed why. Imprisonment for life is imprisonment for a term. Within the meaning of section 428, we'd like to add that we find it difficult to agree that the expression imprisonment for life and imprisonment for term are used either in the penal code or in the CRPC in contradistinction with each other. Section 304, 305, 307, and 394 of the penal code undoubtedly provide that persons guilty of the respective offense shall be punished with imprisonment for life or with imprisonment for a term not exceeding in certain numbers of years. But that is not the only manner in which the legislature could have expressed its intention. That persons who are guilty of those offenses shall be punished with either of the sentences mentioned in the respective section. The circumstances in which the learned judges have placed reliance in Kartar Singh do not afford any evidence, intrinsic or otherwise, of the use of the two expressions in contradistinction with each other. Two or more expressions are often used in the same section in order to exhaust the alternatives which are available to the legislature. That does not mean that there is necessarily an antithesis between those expressions. The reasoning in Kartar Singh that an order of remission does not interfere with the sentence recorded by the court but merely affects the execution of sentence depends then answered by the interpretation which we have put forth upon the language of section 428 that person sentenced to imprisonment for life are sentenced to imprisonment for a term. It is not because of remission that the sentence of life imprisonment becomes an imprisonment for a term. We have also readily answered the last of the reasons given in Kartar Singh that the question is not whether the beneficent provision contained in section 428 should be extended to life convicts on equitable consideration. We enter a most respectful caveat. Equity sustains law and the twain must meet. They cannot run in parallel system. Equitable consideration must have an important place in the construction of beneficent provision, particularly in the field of criminal law. To exclude such consideration is to denude law's benevolence of its true and lasting content. Lastly, the view expressed by the Joint Committee in its report does not yield to the inference that the mischief sought to be remedied has no relevance, where gravity of offense required the imposition of punishment for life. As we have indicated earlier, graver the crime, longer the sentence, and longer the sentence, greater the need for set-offs and remission. Punishments are no longer retributory, they are reformative. The order passed by this court in Suklal Hansa related to the case of 24 prisoners who were sentenced to life imprisonment. Most of those prisoners has undergone imprisonment for a period which, after taking into account the remissions earned by them, exceeded 14 years. It was held by this court that for the purpose of considering whether the cases of those prisoners should be examined for premature release under the relevant provisions of the West Bengal Jail Manual, there was no reason why the period of imprisonment undergone by them as under trial prisoners should not be taken into account. The court directed the cases of the British prisoners should be considered by the state government, both for the purpose of setting of the period of detention undergone by them as under trial prisoners and for taking into account the remissions earned by them. The order passed by this court does not discuss the point which arises before us, though the observation made therein are consistent more with the view which we have taken than with the view taken in Kartar Singh. For the reasons we have allowed the appeal and the repetition and direct that the period of detention undergone by the two accused before us as under trial prisoners shall be set off against the sentence of life imprisonment imposed upon them, subject to the provisions contained in section 433A and provided that orders have been passed.
Yes.
My lord, as I was reading on just a couple of minutes back, that the life term, because of uncertainty, this has been very nicely presented in this para 8 of the judgment, my lord. Same judgment, my lord. The lordship is there.
Yes.
To say that the sentence of life imprisonment imposed upon an accused is a sentence for the term of his life does offense neither to grammar nor to the common understanding of the word term. To say otherwise would offend not only against the language of the statute, but against the spirit of the law. That is to say, the object with which the law was passed. A large number of cases in which the accused suffer long under trial detention are case punishable with imprisonment for life. Usually, those who are liable to be sentenced to imprisonment life are not enlarged on bail. To deny the benevolence of section 428 to them is to withdraw the application of a benevolent provision for large majority of cases when such benefit would be needed and justified. My lord, your lordship will also find that in the paper book, I am reading the 11th para of the impugned judgment at para 89. The London trial court record this thing. As the aforesaid convicted have been sentenced to undergo life imprisonment, benefit of the provisions of section 428 of the Chris 12 CRPC, 1973, shall not be available to them. So what happened is that, your lordship, today, finally, if I get acquitted of this trial, acquitted of this case, I have already spent 19 years. Already spent 19 years. Now, your lordship, I will give a two situation. If my lords held that, yes, the judgment of the London trial court is perfect. So the consequences is that even after having 19 years underground in custody, the benefit of remission won't be applicable to me because there is a finding of the London trial court. Second is that if my lords find that the London trial court has erred in its judgment, the lordship set aside its judgment. I come out. But still, my valuable years, which I have ought to have got, because even if I had got the remission, my lord, my appeal would have continued. I would have come out. The problem is these are two peculiar things, my lord. I have been told the accused persons, my lord, they come from a very indigent family. So their sons came, when they approached the accused persons in the jail to meet they were saying that the government has proposed that to release people who have gone for remission. But because of this hindrance, the jail authorities are unable to look into it. This is one fundamental flaw which I would like to highlight, man. Let us go. The lordship will kindly take part 1 of the paper book, page number 12. The lordship has the index which I have given, my lord. I have given 2 index. If your lordship doesn't have, then I can give the press.
No, we might have.
Index from Athani. How about it? আছে? The lordship will kindly see page 12.
Yes.
This is the first Ezehar was by Anil Chandra Dev. Humble submission is that on 9 a.m. yesterday, that is on 17th of March 2004, my elder brother Sri Putul Dev, his driver Munia Lakar and his Mohori clerk Muhammad Jalaluddin left home for Bhairavi in my elder brother's own vehicle, AS 241433. In between 11:30 a.m. to 12 noon, some young militant abducted the tree from Haichara and left the vehicle by the side of the road. I therefore earnestly pray to your good self to rescue my elder brother, Sri Putul Dev, his driver, Sri Munia Lahakar, and Mohori, clerk Muhammad Jalaluddin from the classes of young militants and obliges. Dated 18th of March 2004. Received and registered as KTC PS Assessment Katisara PS case number 19 of 2004, dated 18th of March 2004 under section 364A IPC. So in the FIR, my lord, it was they were saying some young militants. Your lordship will kindly come to page 7.
Page PW2.
His PW2. Anil Chandra Dev. Now kindly come to my lord page 7. This case
Page?
page 7.
Yes.
This case is registered in compliance with the order of the Honorable High Court Guwahati, dated 12/4/2005. Your lordship will kindly appreciate that one. 12/4/2005. And the FIR which was registered, it was of 18th March 2004 by the brother of the deceased. These two dates are very important, your lordship. 18th of March 2004, the FIR was lodged by his brother at Katisara PS, which was registered as Katisara PS case. Now, the Honorable Guwahati High Court, by order dated 2005, directing CBI to find out the culprits who are behind the alleged kidnapping of Sri Putul Chandra Dev, son of late Guru Prasad Dev of Katisara, district Hailakandi, Assam, passed in PIL number 48 of 2004, filed by Assam Enviro Legal Protection Society and NGO of Dispur, Guwahati, seeking issuance of a direction for CBI investigation into Katisara PS case number 19 of 4, which was registered on the complaint of Sri Anil Chandra Dev, father of Sri Putul Chandra Dev. Accordingly, investigation of the said Katisara PS case number 19 of 4 has been taken over by RC 3S/5 of Kolkata, treating the said FIR 19 of 4 of Katisara PS as FIR of this case. The copy of the FIR of Katisara PS case 19 of 4 received from SP Hailakandi is enclosed, the translation version of which is as under. So, my lord, the CBI registers the FIR. Your lordship will kindly come at page 5.
No, what happened to the Azahar of 18/3/2004?
Exactly, because that FIR Azahar lost by the brother. Nothing moved forward. There will be evidences which will show that the charged party with the brother and all, they were going with the concerned police station. The SP of the district says that, where are you going? So we are going to find out this. Oh, turn back. There is some evidence on record. There are evidence on record. So 18 March FIR, which was registered by brother, that kept quiet. So this NGO came. This NGO came because, your lordship, to be very frank, honest, this matter was related to some other ulterior thing was there, facts were there. So in the PIL it was pleaded. But now I am also surprised. The order of this PIL, we don't find in the High Court. We do not find in the High Court. We have applied for the certified copy. And even my friend doesn't have the copy of the order. When it was presided by court number 5, if I'm not wrong, when we pointed out, Honorable Justice Suman Shyam said that I might be related with this NGO. But where is that order? We applied for the certified copy. We tried this order of the order has not been. We don't find it. And the person who approached the High Court, the Lordship, basic knowledge of criminal law will say this daughter who implicated those persons, she has not been examined by the CPI. If a Lordship finds the order sheet, it will be there in the order sheet. And second thing was that you
read page 7, the second paragraph.
Page?
Page 7, the registration of the FIR. The second paragraph makes it clear. Accordingly.
Yes, they have taken over the investigation. Your Lordship query was there. What happened to the earlier Azehar? The investigation was not moving ahead. That's why that NGO came before this honorable court, because they lost the fate of the local police. The honorable division bench said that let it go to the CBI. Now, the question is that from 18th of March 2004 till the registration of this FIR, that is of 24/2005, and this FIR was lost on 20 April 2005. Your Lordship will kindly find it page 5 of the paper book. The FIR form, my lord. CBI registers the FIR number RC 3S 2005 Kolkata, dated 24/2005. The incident is of 17 March 2004. Now, your Lordship will kindly come to page 6. Details of suspected or unknown suspected accused person, young extremist.
What is the PIL number?
PIL number was 48 of 2004. And one more very interesting thing which I would like to highlight, if my friend can assist me in this report. My lord, as far if I refer to the IO evidence PW 36, there's no record of handing or taking over of the Katisara PS case record. And this particular FIR, my lord, though it has been in the judgment, it has been said that it is exhibited as Exhibit 167. But the Exhibit 167 pertains to a different document. This particular document has not been exhibited. In my table, I have given that one, your Lordship. I have highlighted, which I have said. Because your Lordship will appreciate that this subsequent registration of FIR is hit by 160. It's just a 161 statement. Now, your Lordship will, I don't know when did I, how did I came into picture. Because FIR was registered in 2004. Till 1 year, my lord, I don't know where it was. Suddenly we have been arrested. I sought the records, my lord. Where I was arrested, where is my arrest memo? I don't find the arrest memo also. If my learned friend can help me out, because arrest memo is a vital piece of document. In my confession statement, so-called confession statement, your lordship will appreciate one thing. My lord, recently certain developments has happened in the law, particularly in the draconian law of UAPA, PMLA, the grounds of arrest. Earlier it was said that it was like a ceremonial thing, the arrest memo. The Honorable Supreme Court has said that no, these are sacrosanct as far as Article 22 and Article 21 is concerned. Now, what happened in this matter is that I was caught. I was behind with them in custody for almost 7-8 days continuously. I was brought. I don't know. My statement was recorded. Subsequently, retraction was there. That's a different thing, my lord. But the learned magistrate also did not assert that when, where and where I was arrested. And where is the arrest
After
memo?
how many days the taking over by the CBI took place, happened?
My lord, as per the
48 of the PIL,
yes,
48 of 2004, what is the order passed? Which date?
my lord, order was passed in 12/4/2005
By the High Court.
by the High Court.
Almost after a year from lodging of the initial Ajahar on 18/3.
Yes, my lord. Your lordship will kindly appreciate this thing. The FIR which they have recorded, CBI which has recorded, they say that Honorable Guwahati High Court has passed the order on 12/4/2005 in the PIL number so and so.
Yes.
Accordingly, the investigation of the Katisara PS case number so and so has been taken over. That FIR has been taken over. True copy of PS Katisara PS case number 1904 received from SP Hailakandi is enclosed. This is the enclosed part. Now, my lord, if we go to the FIR form, date of incident, registration of the FIR, your lordship, is 20.
Earlier page.
Earlier page, page 5.
Yes.
Page 5. Serial number 1, District PS, Kolkata CBI PS, year 2005. FIR number RT3S 2005, Kolkata 200405. My lord. Suspected offense, date of offense, my lord. Criminal conspiracy and abduction for ransom, day 17/3/2004. Kindly come. Type of information, written, my lord. Place of occurrence, offense, Bhaisara PS Katisara. Anil Chandra Dev. Your lordship will kindly see 8, serial number 8. Reason for delay in reporting by the complainant or informant. Your lordship, there are two types of argument we can. Once you
They have
have
said no delay.
no delay. If we go by the book, yes, there was a delay for the CBI because incident happened 1 year back. We came because your own document is saying. So how can you in your entries, though FIR is not an encyclopedia of events, my lord, but the particulars has to be there. Now this, if your lordship will kindly, I will take out your lordship to the subsequent aspect. But I want to see where are the arrest memo. Where I was arrested. I don't find so. Even in the paper book, your lordship will see. My lords will kindly peruse at the index FIR as a charges with 4 heads. Where is the arrest memo? Because that is a vital thing.
No, in the paper book, it may not be there. It will be in the record. It's part of the investigation.
My lord, arrest memos has to be, because how do you prove an arrest of an accused person?
No, that's a point you have taken, but it's not necessary that since it's not mentioned.
Verify from the record, my lord. I got it from the certified copy in the trial court. I don't find so. The arrest memos were not there. That's why I'm asking that if my friend can assist. These are the original court's orders, my lord, which we got it from the learned court below. As per the trial court's record, this is certified copy. 25/10/2005. 25/10/2005. I was produced with one accused, co-accused, Ranjit Sakma, before the magistrate court, sought for 14 days police leave. So the court allowed. So that means I have to be arrested prior to 2015.
Yes.
That means 24. But where is that arrest memo? There is no record of that. And subsequently, these accused persons have implicated that yes, I was being tortured, my teeth was also broken. You have taken me to medical also. But those things are not there. So, Your Lordship, these are the two things your FIR. Your Lordship will kindly see in the index which I have given. I have raised the appellant's contention on what aspect. So, first was the FIR of 18 March 2004. I was not implicated. FIR that printed form with file with Katisara PS. My name was not. FIR which was been registered by CBI, my lord, of 24/2005. Not exhibited. That is not exhibited. Exhibited 167. That is a different document. Then refer of this paper book. I will take your lordship to that aspect. Now kindly come to your lordship part 2. Part 2, volume 1.
Part 2 of exhibit.
Exhibit, yes. Yes. Page number 157.
Page number 157. Page number 2. Volume 1.
Part 2, volume 1.
Volume 1.
Page number 157.
7 years.
157 is the translated copy, my lord, typed copy. Kindly come to 158. What is it?
Yes, 2510.
2510. Here is put up before me today In the order of learned CGM Hailakandi, as per the state order, accused Khagenda Sakma Khogen and Ranjit Sakma Kora are produced before me one after another. I have explained to them separately the consequences of making confessional statement, that they are not bound to make one, and if made, that may be read in evidence against them at trial, to which they show their willingness to make confessional statement. Send them to jail under judicial custody with a direction to the superintendent jail, Hailakandi, to keep both these accused persons segregated from other UTPs, so as to afford them a congenial atmosphere within the jail premise to reflect about the matter. The superintendent district jail, Hailakandi, be informed accordingly. 6/26/10/2005 for production and confession statement at 10 a.m. So this is the confession statement aspect, my lord. Now, kindly come to the order of 10/9/2005. Sorry, my lord.
Order of
25/10/2005.
that we have seen 158.
No, my lord. There are two orders. Accused Khogenda Sakma, alias Khogen, and Ranjit Sakma.
Page.
Well, that will have to be in your trial court record, which I have tried to. I got it. I got it. Trial court. That has not been put in the part. I'm reading the order, your lordship. Your lordship, that order is there 25/10 of confession state. Accused Khagenda Chakma alias Khogen and Ranjit Chakma alias Khora. He had been produced before this court today by C.S.K. Mr. CBI Inspector Hailakandi camp. After expiry of 14 days, police remand. They are remanded in jail custody till 7/11/2005. There is an order of till 7/11/2005. Subsequently, this order was being passed that you produced before 26/10 before the for confession statement according. Now, my question is, dear lordship, the arrest memo of the accused person.
Yes.
There is nowhere mention of that arrest aspect, and that arrest memo is not on record. That aspect, which on a earlier occasion also, if my friend can recollect, that aspect also we have supposed to look into it. Where are the arrest memos? Because that's a vital thing. Because by face of this record, my lord, how many days I was in custody of police custody, that is totally silent. Because in judicial custody, I came subsequently, but before that, where I was, and for how many days?
But the order which you had just read before is 25/10.
My lord.
From where you have said that when they were remanded to judicial custody.
My lord.
From that, can't we decipher from which date he has been arrested?
Sir, that way, of course, we can decipher that we have. But how long? Where? When?
Now, the aspect of arrest memo, after the trial is over, judgment has been passed. This definitely is a relevant factor, but the relevancy would be much more at the time of the trial when you are arrested, not given the arrest memo.
My lord, of course.
Right now, here we are, much water has flown. Now, should there be a very important issue for you, or should we go by the other evidence?
The lordship, as your lordship is very fair enough to put me this query. Let me try to answer it in this. Your lordship, the prosecution accepts before the learned trial court that, my lord, your honor, the entire case is based upon the circumstantial evidences, a confessional statement, and second is that leading to discovery of certain.
We'll concentrate on those two. If we find that the confession statement does not meet the requirement of law, neither truthful nor voluntary,
My lord,
then it may not be sustained. And so far as 27 is concerned, we'll see whether the rigors of 27 has been, because 27 is an exception to 26.
my lord.
So with that being an exception, it's some statement made by an accused still being made relevant under 27. Of course, obviously it needs to pass by the rigors.
Rigor.
So if it's not, if we find flaw, you may have a case. Let's go to that.
My lord.
Okay.
So why I was trying to point out this was there, my lord, since the learned trial court began with the confession of the co-ed.
No, that we have already conveyed.
That is the point, your
We
lordship.
have conveyed. Yes.
My lord, your lordship will kindly see the confessional statement.
Yes.
My lord will find it 161.
Of the part 2 file.
Same, your lordship, which I am referring. Part 2.
How many appellants are before us convicted?
My lord, we have got four.
In 3 appeals,
Pardon me?
in 3 appeals, there are 4. In 1 appeal, that means there are 2.
One appeal I might be there, might be two.
No, I think there are 3 appeals or 4 appeals.
4 appeals, my lord.
Or
Four appeals.
one each.
Yes, one.
Okay.
One is been granted bail.
No, it doesn't matter. Bail, but 4 appeal for 1 each. 5 minutes? We'll take a break for 5 minutes.
Hello. Purabha and Kalpanu left for Tripura. After the weapons were kept ready, Pura and I informed Budul about it, and Budul said that after completion of the task, he would give us 1 lakh rupees. I owed Budul an amount of 33,000. After that, I gave Kishan Madhav and Kalijoy rupees 2,600 to buy dress. Thereafter, Hurubura, Kalpanun, Kishan Madhav and Kalijoy came together. On the following Wednesday, Putul Dev was kidnapped. That night, Hurubura and Kishan Madhav took rice and 2 blankets from our house. I sent Batibura with them to show the way. After 7 days, Batibura came and told me that Putul Dev had been killed. 3 days later, I informed Budul about it. Budul said nothing except that I should not have to face any problem. After 15 days, Hurubura came to my sister's house and gave me 20,000. Budul Mia gave me 10,000 instead of 1 lakh rupees. Later, Budul gave me 5,000. After a few days, Budul threatened me by mentioning about police. This is the statement, my lord. At best, if I read this statement again and again, I know that there was a dispute between Harimia, Budul Mia and Putul Dev because they were involved in bamboo business. I say that I gave 2,600 for buying of army dress. I say that I've given rice to those persons on that very fateful night. My lord. So what this statement, if you read, it is It is not inculpatory. That he is not confessing that yes, I was a part of the confession, but conspiracy. I am implicating. If we say I am implicating, yes, I have heard, I knew, he told me, I gave him rice. They bought the arrange of the bamboo sticks, pipes. For what was the reason for those pipes? I don't know, my lord. So this statement, if you read, it is exculpatory. So your lordship will appreciate this two facts as far as the confession statement is concerned. The first doubt which I was raising before your lordship, something my lords appreciate the same, that I was questioning the day on which I was arrested, how long I was in custody. That facts, because I am not supposed to prove in criminal matter, I am not supposed to prove it to the hilt. If I bring up doubt. So that doubt, that issue gets fortified if your lordship look into question number 2 at page number 163. Because if I take this 11/10/2005, my lord, I was placed under observation detailed narration on 11/10/2005 in village town city of Sarbarai. So that means, my lord, either he doesn't know whether he is in judicial custody or whether he is in police custody. He doesn't have to difference. One argument which I can give. Or second, if I give that argument, that means this man is not sure where you was exactly. Second, your lordship, the entire statement. Later on, I will try to take your lordship. But prima facie, at this stage, this statement is exculpatory in nature. Now, your lordship will kindly see 26/10/2005, order of the magistrate. Page number 160, my lord.
Yes.
I am of the opinion, my lord, first para, top para, from the third line from the top. So I am of the opinion that a confession is true and voluntary. After recording his statement, he is made to go muffled, accompanied by police. Which police? What police? He is not. Means he was under the influence. It's a record of the learned trial magistrate. Now, your lordship will kindly come. The charge sheet. Now, this was the pre-trial, my lord. This thing was the charge sheet. Your lordship will kindly find at part 1, volume 5.
Part 1.
Volume 5. Why I'm referring to the charge sheet, the final report, is the
Page.
page number 1267, my lord.
What is this?
This is the charge sheet, my lord, filed by the CBI. Kindly come to page 1270, my lord. This is very interesting, my lord.
Yes.
The local police during the investigation arrested 21 accused persons and examined a number of witnesses, family members of Sri Putul, Chandra, Dev, and others. Presently, all the arrested accused are on bail. One of the arrested accused, Upender Young, made a statement under 164 CRPC admitting his guilt in the abduction of Sri Putul Chandra Dev. Pause here, my lord. We just pause here. And if we go back to page 126.7, the charge sheet, the column of arrested person. These gentlemen,
Yes.
has been cited, has been referred at serial number 1 in column number 2. Name and address of accused person not sent up for trial. His name is been shown as person whose name is there, but he's not been sent up for trial. But his confession statement is there. That is the CBI's version, my lord. And I don't understand if he is not sent for trial and he has admitted his guilt. So either he has to be an approver, he has to be an approver, or the court has granted him pardon. Where is his statement? What did he say in the statement? While the investigation was being conducted by the local police, Govt of Assam issued a notification number so-and-so, dated 10/3/2005, under Section 6 of DSP Act, and gave his consent for investigation by the case by the CBI. While the matter of notification under Section 5 of DSP Act was pending with Government of India, the Honorable High Court of Assam passed appropriate order transferring the investigation of case to CBI. Now, kindly come to para 3, third para.
This Upnanda Young is a PW.
Pardon, my lord?
He's a PW.
No, my lord. So that's why you begin with in the charge sheet that this man, when the investigation was conducted by the Assam police, Katichara PS, this man gave a 164 statement. So where is that 164 statement? And where is the record, my lord? That's why when I was referring your lordship that at the very beginning.
But this is prior to registration of the case by the CBI. It is even prior to the High Court's direction.
Exactly. So that
So
question.
has the statement made any difference in the trial?
No, my lord.
To your conviction?
No, my lord. The question is that your lordship will appreciate this fact. CBI come into the picture because when NGO files the matter. See, the Honorable High Court said that you take up the investigation by the order. CBI registers the FIR, saying that in pursuance to the Honorable High Court order, we have taken over the investigation of Katisara PS, and all the records have been taken over. So if all the records have been taken over, and you say in your final report for the court that yes, when the Assam police was investigating the matter, one accused person, many people were arrested, and one of them, namely Upandor Young, he made a confession statement under 164. And you file a charge sheet, you show his name as not as an accused. So the curiosity comes is that because your lordship will appreciate it, investigation does not get stopped at any stage. Investigation may be stalled or there may be some ifs and buts, but investigation did not stop. Either because the moment the FIR was registered, the criminal case comes into motion. So what the CBI did, CBI further took up the investigation. So when you further took up the investigation, the records of the Katisara PS investigated by the CBI, it will form a part of the CBI's investigation. So if it would not have been, why this fact would have been mentioned in the charge sheet?
No, see, Mr. Bhargava, this is the charge sheet after completion of the investigation. Thereafter, charges have been framed by the court. You pleaded not guilty, you have been tried. Why are you going back now? Why don't you show us the materials that the trial court has considered this, which you have already indicated, that the confessional statement and discovery statement.
My lord.
Challenge those, assail those, and
Why I was trying, absolutely, my lord, why I was
why
trying
are you
to,
going back? Show us how the confession is not admissible in the eyes of law. Why this discovery statement of 27 is not admissible?
the lordship, then
Since you have been harping that these are the, except these two materials, there are no materials. If the learned PP is agreeing to that proposition, we will examine thoroughly this confessional statement and 27 statement. Why do you go back?
no, why I was trying to look into is
No,
that.
no, why? Because this is not the basis. After the charges have been framed against you, you have been tried for those charges. While trying, some materials have been used against you, which you say that are not in accordance with law. Assail those, show us.
My lord, your lordship will kindly come to certain evidences which I am relying now.
Yes, please
Yes.
show us. Why do you go back now?
PW want to do it.
See the volumes of this. We have spent more than 1.5 hours. We have not proceeded anything, not even a single witness.
My lord will kindly come to
Which one?
part one,
Part 1.
volume 1.
Volume 1, yes, we have got.
My lord is there.
Yes.
Jalaluddin Majumdar. Jamaluddin Majumdar, my lord.
Page?
Page number 22.
Yes.
He is the victim and eyewitness. Your lordship, his evidence is too long. I will just in the index which I have given to your lordship,
Yes.
relevant part,
Yes.
page part and page number. But I will begin with the introduction part. I knew we are 7 brothers and 3 sisters. I am the eldest among them. I have passed metric examination and also Hindi Pisar. I know Putul Chandra Dev. I am a member as well as Gaon Panchayat, president of a political party, namely Bharatiya Janata Party. When Putul Chandra Dev returned from London, he showed his desire to join in the BJP in the year 2000. Accordingly, he made arrangement of different political meetings, and in that way, I came in contact with him. Kindly come to page 23, my lord. Last para. On other days before going to Bhairavi, Putul Chandra Dev used to visit the Garmura to attend Budul's shop. But on that 17/3/2004 day, he did not have time to visit Budul's shop at Garmura and straightway proceeded towards Bhairavi. After crossing Ramanpur and while reaching the hills of Baichara, I saw 2 gunmen in army uniform coming from both edges of the road as signal to stop our vehicle. Putul Chandra Dev, under the impression that there was security checking, asked the driver Muni Lohar to stop the vehicle.
Munia is a witness.
Yes, my lord.
Number? PW4. Yes.
As the vehicle stopped, some other persons came with dao and lathi, following another gunman and surrounded the vehicle, and they were 8 in numbers. At that moment, 2 youths came with motorcycle. All these 8 miscreants asked the motorcycle-borne youths to sit in our vehicle by leaving the motorcycle on the road. Initially, we 3 came in the Mahindra Jeep. Then 2 motorcycle-borne youths also boarded in our vehicle. Perhaps 2 gunmen boarded in the rear seat of the vehicle and other gunmen boarded on the footboard of our vehicle. In reply to the questions put by Putul Chandra Dev and to why their vehicles were stopped, one of the gunmen stated that Putul Chandra Dev had to meet their boss. The gunman asked us to take another route instead of the route towards Bhairavi. The said road was a kacha road and therefore the vehicle could not take speed. However, after crossing about 2.5 to 3 kilometers, the gunmen stopped us and made us alight from the vehicle. Thereafter, the miscreant asked us to move further toward jungle. While moving, I saw a stranded truck on the path. On further moving, I saw a man who was cutting wood. One of the gunmen had a conversation with the woodcutter, but I could not follow their language. About crossing about 3 furlongs from the place where we met woodcutter, we saw another person wearing shirt, pants, shoes, who was about 25 to 30 years. The gunman took that person also along with us. After going a little ahead, we came to know his name is Sadannath of Ramnathpur. Thereafter, we were taken inside a dense forest surrounded by hills, and we traveled about half furlong. Then Putu Chandra Dev became senseless. Me, the driver, and one more person rendered treatment to Putu Chandra Dev. On regaining sense of Putu Chandra Dev, we were further compelled to move ahead. After going a little depth, Putu Chandra Dev became unable to proceed further. At that place, I was checked whether I carried any arms. Then the gunmen checked the driver and one of the motorcycle born youth, namely Ataur Rahman, whose name I could not know afterwards. The gunman directed me to ask Putul Chandra Dev to remove the gold ornaments and to hand over his same to the gunman. Then led us to a bit of far below the hills, surrounded by other hills from all sides, and the miscreants surrounded us. The place where the miscreants surrounded us, perhaps not situated far from railway line, because we could hear sounds of railway. We were kept sitting in that place for remaining part of the day until 9 to 1:10 p.m. None of them boss came to meet us as they assumed. One out of the said miscreants bringing drinking water and blankets provided us the same. Then the miscreant demanded Putul Chandra Dev a sum of 50 lakhs for his release. Then Putul Chandra Dev replied that he had incurred loss in the previous year in the business, and therefore he was not in a position to pay such a huge amount. Then the miscreant reduced the demand to rupees 40 lakhs. Then the miscreant taking me separately, asked me to tell Putul Chandra Dev as to how much amount he would be able to pay. And accordingly, on being asked, Putul Chandra Dev told me that he had ability to pay about 1.5 lakhs to 2 lakhs only. And I informed the miscreants accordingly. Then the miscreants had a talk with Putul Dev that they demanded a sum of 40 lakhs, and out of that, Putul Chandra Dev agreed to pay 2 lakhs only. And then Putul Chandra Dev requested the miscreant to accept 2 lakhs at that moment and told them that after his release, he would be able to earn more and pay demanded sum. Thereafter, the miscreant took away gold ring, gold chain from his possession and cash from the bag of Putul Chandra Dev. When the miscreants took away cash from the bag, I asked Putul Chandra Dev about the contents of the bag, to which he told me that the bag contained 20,300 approximately. Then the miscreants gave us 3 days time to hand over the demanded sum at Churanga situated Bhairavi. Then the miscreants inquired about contact number for communication if there was any change in the dealing. Then I gave telephone number of one Sushil Dev, brother of Putul Chandra Dev. After discussing with Putul Chandra Dev, then the miscreants made a discussion to release all of us except Putul Chandra Dev, but I refused to leave. Putul Chandra Dev alone, to which Putul Chandra Dev told me that the driver would not be able to contact the other businessmen to hand over money, and therefore I had to leave Putul Chandra Dev there. Thereafter, the miscreant took us to a railway line, and towards the dawn on the next morning, the miscreant allows us to leave place for collection of money. But I refused to leave Putul Chandra Dev because of his ill health. Then the miscreant, showing underman who was taken along with us from our roadside, proposed to keep him with Putul Chandra Dev and allowed us to leave the place. Then we proceeded along the railway line towards Bhairavi, and one of the motorcycle-born youth told us that his residence is not far from that place. Then he took us to his residence at Rajodal. We took water there, and the said youth with a bamboo-made torch helped us to proceed towards Bhairavi, Choranga. At Choranga, we met Munia Lohar and Jasimuddin, who were the employees of Putul Chandra Dev. They inquired about our arrival in the night, and we narrated entire incident to them. Then we made a telephone call from Bhairavi railway station to the house of Putul Chandra Dev at Katichara. We had talked with Sushil Dev, who is the brother of Putul Chandra Dev, but he asked us to proceed towards Jamila police station immediately. When we asked Sushil as to how he would proceed to Jamila police station, to which Sushil advised me to take a sumo taxi, and accordingly we proceed toward Jamila outpost under Katichara police station. We arrived Jamila outpost where we met Sushil Dev and his son Sunil Dev. In Jamila outpost, police recorded our statement and we narrated the whole episode to the police. Then we proceeded to the house of Obati Riang, a social worker. We also narrated entire episode to the said Obati Riang, and she asked about the statures and description of the miscreant. Then we proceeded to Katichara police station where police got Munia Lohar medically examined. Thereafter, we proceeded to our respective houses. Giving all information in my house, I again proceeded to the house of Sushil Dev. After a few days of the said happening, wife and daughter of Putul Chandra Dev came from London in Katlisara. In the meantime, on 23/4/2004, Sushil Dev, Munia Lohar, and we proceeded to Bhairapi Choranga as stipulated by the miscreant. We waited there for a whole day, but none of the miscreants came and met us. On the next day, Jasimuddin came from Bhairavi Choranga to the house of Sushil Dev and informed that 3 boys came to Jasimuddin at Bhairavi Choranga and inquired whether anybody had come from the house of Putul Chandra Dev, to which Jasimuddin affirmed that those 3 boys that on the previous day, 3 persons from the house of Putul Chandra Dev waited there for a whole day, and then 3 boys requested Jasimuddin to inform the house of Putul Chandra Dev to send persons with cash again. Then on 21 March 2004, Sushil, his son Sudeep, Munia Lohar, and me went to Bhairavi Charanga. But we waited there for a whole day and night, and we left the said place on 22 March 2004, and we could not meet any of the said boys. We returned to the house of Sushil at first on 22/3/2004. After our arrival, Anil Dev, another brother of Putul Chandra Dev, informed us that they received a telephone call that the miscreants did not approach us and Bhairavi Charanga to collect money because we are large in number. Then Kanok Sen, Sudeep Sen, Munia Lohar, and me and some others, I could not recollect the names today, went to Bhairavi Charanga along with the cost cash of rupees 2 lakh. But on that day also, they did not turn up, though waited there for a whole day. On the next morning, Kanak Sen told us that he is acquainted with some of the residents and in and around the Bhairavi Choranga, and accordingly Kanak Sen had conversation with some of the residents there. Then we proceeded towards railway line, and after covering a considerable distance, we found one small path having footprints made with chappal thereon. Then we followed the said print and we arrived near river. Then we crossed the river with the help of bundle of bamboo. Then again we saw prints on the ground, but we could not find any prints on the ground. Finding no clue, we returned from that place of Katichara. However, I could recognize the chappal prints because of its peculiarity, as Putul Chandra Dev used the said chappal brought from London. The SP P.K. Datta came to meet Chipra Dev and her mother and other family members of Putul Chandra Dev at Katichara. That discussion about the dealings with the miscreants, perhaps on 28 March 2004 or 29 March 2004, the miscreants informed the inmates of the house of the Putul Dev that they would collect the ransom from near the Devdut cinema hall. Then the SP made a plan as to how the matter would be dealt with. Accordingly, some police were engaged in civil uniform to go inside, side by side of us when we proceeded for dealing with the miscreants. Then near the said cinema hall, 2 of the boys called us driver Munia Lohar, and I could identify those 2 boys. When there was a talk on telephone, the demand for release of Putul Chandra Dev came down to rupees 5 lakh.
Your client has been identified on the dog by this report.
No, my lord.
He has not been identified.
No.
At page 30?
No, my lord. Page 30? No, my lord.
Five persons have been identified.
5 other persons.
You are not there.
I was not there.
Other appellants are there.
Other appellants.
All of them.
All of them. Krishna Madhav Chakma, Sahadev Chakma Master, Kalpanu Chakma, Ruptam Chakma. First payment which was made near the cinema hall, it was selected on the day of payment of the first installment. The set to Bhairavi Sangha to release of Putul Chandra Dev. This payment aspect, my lord, in his evidence, my lord, he narrates the incident from the very inception. He narrates the incident. And he says that from his evidence, what transpires is that payment of the ransom and the kidnapping part. And he identifies the following persons in the dock. The 5 of the accused, co-accused. Now, my lord, kindly come to his cross-examination. Page 36.
Yes.
It is not a fact that I am not able to identify the golden color rings produced in the court. I did not see 5 of the accused persons who were identified in the court earlier to the incident. Of course, I saw 2 persons pointing accused Jamaluddin and Hogan Sakma earlier incident. It is not a fact that the accused persons identified in the court were not present at the time of occurrence. It is not a fact that I did not disclose the appearance and statures of the accused persons before the IO. It is not a fact that the accused person walked under me in respect of bamboo business. It is also not a fact that I maintain a register and names of these persons are entered in the register. However, I know that the accused Jamaluddin walked under Putul Chandra Dev, but I do not know whether his name is entered in any register. Putul Chandra Dev used to maintain register as regards his employee. During investigation, the investigating agency brought various persons to Katichara police station, and I was called there to identify those persons. Those persons were brought to police station before the arrest of the present accused person. I assume that the imprint of the chappal being a special one, it might have been the imprint of the chappal of Putul Chandra Dev. It is not a fact that I have deposed falsely, implicating the present accused person in order to save the real culprit. This cross-examination, in a way, tilted towards the prosecution. To be very fair. The Lordship will see Perus PW2.
No, what about the last line? You have page 36, last sentence.
Page 36.
From bottom the 3rd line. I did not see
5 of the accused persons who are identified in the court earlier to the incident.
unknown persons.
Unknown person. But my lord, there was a TIP. TIP was conducted. In that TIP, these victims.
TIP was conducted when?
During the investigation stage.
Obvious, no, when, date?
Date, my lord. Part 2, volume 1. Date. 7/10/2005.
TIP by whom?
Additional CGM, my lord.
No, who identified?
PW, 4 witnesses were asked to identify.
Yes.
PW3 identified only Kalpanu Sakma and Krishna Madhav Chakma.
Yes.
Then PW1, Jalaluddin Majumdar, my lord, which I have read, my lord. Didn't identify me, my lord. Ataur Rahman Lawker. He is also a victim, my lord. He also identified some of the accused persons, but did not identify me.
In the TIP?
No, my lord.
TIP, you said TIP, 4 witnesses are involved.
Yes, my lord.
PW3 has said he identified 2 of the accused persons.
My lord.
And who else? You have been identified in TIP? By any of the witnesses?
No, no one has identified.
No one.
No one.
In the dock? In the dock?
No, my lord.
Not even.
No, no, none of the witnesses has identified. PW2, my lord, the person who lost the Anil Dev, the brother of the deceased.
PW2.
Two. Page number 38. Did not say a word against me, my lord. No, with respect to any other implications. So I'm not relying on this statement. Everything.
No allegations against you.
Nah.
Against Kogendra.
My lord. Kindly come to PW4, my lord.
What about 3?
3 does not implicate me, my lord. Sudeep Dev. He happens to be the deceased happens to be his uncle. Now let us go to the evidence of PW4. He happens to be the driver.
Page?
Page 67. My lord is there?
Yes.
I'm a driver by profession. At present, I worked under Sri Nikhil Chaudhary. Prior to this, I worked under APCI company at Kattisara. And before this, I worked under one Panchu Tape. Prior to working under Panchu Tape, I had an occasion to work under Putul Tape for a period of about 1 to 1.5 years as a salaried driver. Putul Tape had 2 vehicles, which one commander jeep and another armada jeep. I used to drive both the vehicles when necessary. Putul Dev had bamboo business and I used to take him for the said business to Bhairavi and Aizawl in the state of Mizoram. On 17th of March 2004, in between 8:30 to 9 a.m., I along with Putul Dev and PW1, Jalaluddin started towards Bhairavi from the house of Putul Dev. On that day, we used commander jeep. When going towards Bhairavi near Barmura, we halted for a moment. Since Putul Dev did not have the time to wait further at Gomura, as he had to make payment of salary to his staff, we immediately started towards Bhairavi. After proceeding about 2 to 2.5 kilometers from Ramnath, we saw 2 persons with army dress standing on the road who made a signal to stop our vehicle. Then Putul Dev asked me to stop the vehicle, telling me that the army personnel might check our vehicle. Then I stopped the vehicle and the said 2 persons came towards our vehicle from both sides and pointed their guns on the head of Putul Dev and myself. Immediately thereafter, about other 5 to 6 persons coming out of jungle surrounded our village. Then they told us to move our vehicle towards Kacha Road. But I told them that the vehicle would not move on that way, as the road was too high, to which the miscreants gave blow on my stomach. Then Putuldev told me to use four-wheeler gear. When I was about to put the four-wheeler gear, we saw two persons came on a motorcycle from the opposite direction. Then the miscreants asked them to come into our jeep, and accordingly leaving their motorcycle there, they came into our jeep. But I do not know about the identity of the said two boys coming with motorcycle. When going towards the hill, Putuldev asked the miscreants as to which place we were taken. Then the miscreants told that their boss was there in the hillside, and after making conversation with him, the miscreants would release us. From there, we moved about 2 to 2.5 kilometers. But due to bad condition of the road, our vehicle could not move further. The miscreant got us alighted from the vehicle and took us on a foot towards the hillside. The miscreant snatched the key of the vehicle from me, and they also carried a bag and water bottle from our vehicle. After crossing about 1 kilometer or so, we found a person standing by the side of our way. The miscreants also took him with us. Then we all arrived at a hillock, and after crossing the hillock, we found a low-lying area where we were asked to take seat. There we heard the noise of train. We waited there till night, and when the boss did not turn up, Putuldev inquired about their boss. Then the miscreant told us that the boss would come, as information was already sent to him. Then we saw that one person came with water bottle and blanket, and it distributed to us. The miscreants surrounded us, were armed with lathi, dao, and gun. After distributing the water bottle and blanket, miscreants inquired whether we carried any guns, arms. Then the miscreants, taking PW1 to a considerable distance, made conversation with him for a moment. After the said conversation, PW1 coming near us told that the miscreants demanded a sum of 50 lakh. On hearing this, Putuldev handed over his finger rings and chain to PW1 and said to PW1 that if money could not be arranged, the rings and chain should also be sold. Meanwhile, one of the miscreants came to Putuldev and asked about his rings and chain. He also gave a blow to Putuldev when not found those articles. Then Putuldev took return of the said articles from PW1 and handed over the same to the said miscreant. Miscreant also asked as to how much money I had, to which I replied that I am a poor person and I did not have money. Miscreants also took money from those two persons who came with motorcycle. Thereafter, the miscreants brought all of us towards railway line. Then they released me, PW1, and those two boys coming with motorcycle, and took away Putuldev and that person who was found in the jungle. But I do not know their destination. About 3 a.m. on the next day, we arrived in the house of one of the motorcycle-born boys, where we had tea and snacks. From there, I and PW1 proceeded towards Choranga. We narrated the incident to the staff of Putuldev at Choranga, and by that time, when it was dawn, we proceeded to Bhairavi. From Bhairavi, PW1 rang from one PCO to the house of Putuldev. We received an instruction from the Putuldev to go to Jamira police post. On arriving Jamira police post, I found Sushil Dev, his son Sudeep Dev, Anand Dev, and some others. Police inquired us about the incident. I also saw that the said Commander Chief was brought to Jamira police post. From there, we went to Katichara PS by Commander Chief, where we were medically checked up. After medical checkup, I and Jalaluddin went to Putuldev's house. There I left the Commander Chief and narrated the incident to the family, and then I went home. On the next day, PW1 called me in the house of Putuldev, and from there myself, PW1, Sudeep Dev went to Badarpur, Karimganj, and Katkal to collect some money, as Putuldev had businesses in those places, 3 places. On that day itself, we came back, and on the next day, PW1 called me to the house of Putuldev, from where I, PW1, and Sushil Dev went with Bhairavi with Commander Chief. I waited at Bhairavi, and other two went to Choranga. In the night, they two came back to Bhairavi, and we all returned home at Katlichara.
Okay, we'll continue at 2 o'clock.
As I was referring your lordship to with respect to the disclosure statements. Before I go into the disclosure statements, my lord, if we look at the judgment, impugned judgment, But that will help us to go the main issue very precisely. Lordship will see the impugned judgment part 1, volume 5. Commencing from page number 1175. I'm in arraigned as accused number A7, my lord. Kindly come to page 1183.
Yes.
Then the senior public prosecutor A.K. Singh has submitted that the prosecution's case mainly based itself on confessional statements of the accused person and on the TIP. He has submitted the confessional statements can be made basis of conviction if found truthful. He has also stated that the confessional statements can corroborated by the prosecution witnesses numbers 1, 4, and 5. He has submitted that the two prosecution witnesses number 1, 4, and 5 are not only eyewitnesses but also victim of the offenses against him by the accused person. He has submitted that the prosecution witnesses number 5 identified accused number 2, 3, 4, and 5. He also stated that the other eyewitness victims also identify some of the accused persons as the persons involved in the abduction of Putul Sundar Dev, and they have corroborated one another in all material particulars. And these were the citations he has replied. The Lordship will finally find the at page 1188.
Yes.
So, very learned trial court framed 10 issues, 10 questions. The first question is whether the prosecution has been able to prove beyond reasonable doubt there was a conspiracy between the accused number 9 and the accused number 7 to kidnap the victim Putul Sundar Dev for ransom, and that the other accused had become part of the said conspiracy later by coming to know the same and by executing the same. Second issue is that whether the confessional statement of the accused number 1, 2, 3, 4, 5, 6, 7, and 8 are voluntary and truthful and can be relied on in support of the prosecution's case. Now, subsequently, another 7 issues were there, 8 issues were there. Now, look at kindly come to para 9, the decision and the reasons thereof. Taking up para 9, taking up the second of the aforesaid point for determination, let us have a look on the evidence on record. So, what the London trial court did was that, without looking into the other evidences, first went with the confession statement. Now, that aspect, Your Lordship, what the London trial court did was that at para 22, the London trial court discusses the entire confession statement of all the accused persons, and at para 22 records is that it is seen that all the aforesaid accused persons have corroborated one another in all the material particulars. Now let us see whether their statements find corroborated from other witnesses. Now, if Your Lordship will pause it here for a moment, and Your Lordship will kindly have it passed by the Honorable Apex Court in Kurmi's case. Excellent question. SSC online. 1964 SSC online. SC 28. Arshyan Kurmi. Kurmi. My note is there. Harshiran Kurmi. Harshiran Kurmi.
Haricharan, not Harshiran, Haricharan.
Haricharan. Sorry, my lord, kindly come to para 11.
Yes. This is a landmark judgment on accomplice evidence.
Yes.
And
It has
how do you reconcile the illustration along with the substantive position of proposition in the Evidence Act?
My lord, your lordship will kindly find that though confession may be, kindly come to para 13. Para 13. Para 13.
Yes.
Thus, though confession may be regarded as evidence in the generic sense. Para 13, my lord.
Yes.
Last line, fourth line from the bottom. Thus, though confession may be evidence in the generic sense, thus, though confession may be regarded as evidence in the generic sense, because of the provisions of section 30, the fact remains that it is not evidence as defined by section 3 of the Act. As far as the confession, the result therefore is that in dealing with a case against an accused person, the court cannot start with the confession of a co-accused person. It must begin with other evidence adduced by the prosecution, and after it has formed its opinion with regard to the quality and effect of the said evidence, then it is permissible to turn to the confession in order to receive assurance to the conclusion of guilt, which the judicial mind is about to reach on the said other evidence. That briefly stated, it is the effect of the provision contained in section 30. The same view has been expressed by this court in Kashmira Singh, where the decision of the Privy Council in Bhuvani Sahu case has been cited with approval. Your lordship is right, accomplished. So when you try a co-accused, 3-4 persons, so you cannot begin with the statement or confession of a co-accused against me before dealing with other evidence. First, you have to deal with other evidences. What is implicating me?
That is not the proposition which you're trying to. It is a harmonious construction of illustration B2114 and section 30.
My lord.
This is a landmark case. This is not on that. What do you do first? We have to see that whether the evidence of an accomplice has been made the basis of your conviction. If it is so, whether it is corroborated by other evidence. That is the principle.
No, your lordship, I will back to say in a different way. Your lordship, I agree to the position.
Then come to section 30 and 114, illustration B.
My lord.
How do you reconcile this?
Well, this position, even our own High Court also has said.
This is the landmark case, Harisharan Kurmi, 64.
Harisharan Kurmi, what I am trying to say.
Read 30 and 114B.
Evidence Act, my lord.
Yes. Because both the proposition appears to be contradictory to each other, so it has been harmoniously constructed. Read 30 first.
When more persons
Yes.
than one are being tried jointly for the same offense, and a confession made by one of such person affecting himself, and some others of such person is proved, the court may take into consideration such confession as against such other person,
Yes.
as well as against the person who makes such
Yes.
confession.
Then you come to illustration B,
My lord.
114.
A on his trial for murder of
No,
C.
no, no, 114B.
My
Not
lord.
this one. 114B. B. 114.
Yes, my lord.
Illustration B.
B.
An accomplice is
Unworthy of credit
evidence unless.
He is corroborated in material.
So how do you reconcile? This is what Kurmi has said. This is how you reconcile.
That's exactly what I am trying to
30 is the substantive position.
position.
And in view of this
114B.
illustration B, so what is the requirement? Is the requirement of corroboration.
Corroboration.
You cannot be convicted on the basis of an confession by a co-accused or an accomplice. That is the law.
My lord, that's why,
But,
because
you are saying that it starts with confession. It may start, but we'll have to see whether there are corroborating materials in your case.
my lord, if your lordship will permit me, if I read the judgment again. As far as my understanding,
Yes.
my lord, is that,
The court cannot start with the confession of a co-accused.
my lord,
Yeah, you are in your case, you are on the confession of yourself. You are saying that is the basis. We are not on that basis. It's on a different context
No,
altogether.
he framed the issue. If your lordship will read the issue, what was the question that the learned trial court posed? Whether the confession statement of the accused numbers 1, 2, 3.
In a criminal appeal, you are not. You just show us the materials which are against you as per the prosecution and make out a case that these materials will not be sufficient to come to a conclusion of guilt. That's all.
My lord, what I am trying to say is that
What
the-
issues are framed by the lower court? How is it answered? We are not too much confused.
No,
We are
what
in the
I-
appellate court. All evidence are before us. Criminal appeal is almost a continuation of the trial. Whatever you want to show from the records, say to us directly. Why you are going to?
Your lordship, as far as my confession is there, your lordship, I have already demonstrated that is already an exculpatory.
That you have said.
That I have exculpatory.
Now let us see other materials.
Other matters, like lordship. So learned trial court has framed the view that as recorded in para 222, that it is in the aforesaid accused person have corroborated one another in all material particulars. Now let us see whether their statements find corroborated from other witnesses. Now it comes to the disclosure statement, my your lordship. Disclosure statements your lordship will find disclosure statement of Sahadev Sakma, part 2, volume 1, page number 34.
Volume part 2.
Part 2, volume 1.
Yes. Page.
Page number 34.
Yes, please.
Your lordship, it has been said, I state that after kidnapping and murdering of Sri Putul Chandra Dev about 1.5 years back, I had taken the gold chain of one bazuban and one gold bracelet from the person of Sri Putul Chandra Dev. These golden items were given by me to a jeweler in Manu Bazar, who melted the same and prepared 2 golden chains. These 2 golden chains were taken by me to a hardware shop in Chalanga Bazar and given to the shopkeeper at different dates for rupees 10,000 each. If taken, I can show you the jewelry shop in Manu Bazar and hardware shop in Chalangata Bazar, where the said golden ornaments of Sri Putul Chandra Dev were disposed of. Page number 35. Subsequent to my earlier statement, I stated the gold chain of Putul Chandra Dev was written by me, that this chain was mortgaged by me with the shopkeeper of Chaling Bazar for rupees 10,000. I can point out the shop and it is keeper to whom I had given this chain if I am taken to that place. Now discovery come, Caesar memo, my lord. Your lordship will kindly find the signature of the officer, the IO who has recorded the disclosure statement, SK Mishra.
Page?
In the same page, my lord, page 34. There's one typed one and there's a handwritten one. Your lordship will kindly find
34, yes.
Yes, my lord,
Yes.
SK Mishra.
Yes.
Now, if we pause here for a moment and we go to the evidence of SK Mishra, who happens to be the CIO, PW 35.
Yes.
My lord is there.
No, where are you now?
Now, your lordship, I have shown your disclosure
Yes,
statement.
SK Mishra, we have noted.
Yes, my lord. Now, the person who recorded the disclosure statement is the IO.
PW,
PW 35.
in which volume?
The volume, your lordship, part 1, volume 1. Containing the FIR and evidence. Same
Page?
Page 232. It commences from 231, the 11 pages 230. Kindly come to page 232. My lord, your lordship is there.
Yes.
Page 232, third para. During investigation, I have examined witnesses and recorded statement as told by them. Besides, I have effected recovery of dead body of Putul Chandra Dev and one Satannath, who happens to be a bamboo work. In this regard, I have prepared recovery memorandum. Exhibit 7 is the state memorandum, which bears my signature. 715 is my signature. I recorded disclosure statement of one of the accused, Sahadev Chakma, who is present in the court. Exhibit 8 is a said disclosure statement. Exhibit 84 is my signature. Another disclosure statement of the said accused was recorded by me on 895. Exhibit 9 is a said disclosure statement, and Exhibit 94 is my signature. Full stop, your lordship. Now I want to say, your lordship will kindly see section 27. We are all aware about it. Now, how do you prove the disclosure statement? Whether this disclosure statement has been proved by the evidence? Answer is no. Your lordship, I put one judgment before your lordship. Kindly look into produce the judgment. Your lordship, it's Babu. Kindly come to para 58. Yes, okay. Stop it. My lord is there?
Yes.
We would now discuss about the
Paragraph?
paragraph 58, 58. My lord. We would now discuss about the requirement under law so as to prove a disclosure statement recorded under section 27 of the Indian Evidence Act and the discoveries made in furtherance thereof.
58, the High Court really relied upon the circumstance.
No. Para 58, 58.
Yes, the High Court heavily relied on the circumstance.
Your lordship. Babu Sahib Gora.
Yes.
My lord.
How does it start? Line, this
My lord, it is
sentence.
we would now discuss.
That is 60.
Oh, my lord, my
Doesn't matter. We would now discuss about the requirement.
requirement under law.
60.
And-
Brother, 60.
So sorry, my lord.
Doesn't matter.
We would now discuss about the requirement under law so as to prove a disclosure statement recorded under section 27 of the Indian Evidence Act and the discoveries made in furtherance thereof. The statement of an accused recorded by a police officer under section 27 of the Evidence Act is basically a memorandum of confession of the accused recorded by the IO during interrogation, which has been taken down in writing. The confessional part of such statement is inadmissible, and only the part which distinctly leads to discovery of fact is admissible in evidence, as laid down by this court in the case of State of Uttar Pradesh versus Deuman Upadhyay. Thus, when the IO steps into the witness box for proving such disclosure statement, he would be required to narrate what the accused stated to him. The IO essentially testified about a conversation held between himself and the accused, which has been taken down into writing, leading to the discovery of incriminating fact. As per section 60 of the Evidence Act, oral evidence in all cases must be direct. The section leaves no ambiguity and mandates that no secondary or hearsay evidence can be given in case of oral evidence, except for the circumstances enumerated in the section. In case of a person who asserts to have a heard a fact only his evidence must be given in respect of the same. The manner of proving the disclosure statement under Section 27 of the Evidence Act has been subject matter of consideration by this court in various judgments, some of which have been referred to below. So judgments have been referred, my lord. Similar, kindly, my lord, it will be a similar view. Your lordship is there. In Mohammed Abdul Hafiz, my lord, in the case of Mohammed Abdul Hafiz, that was been expected here. Then similar view was taken by this court in the case of Ramananda versus State of Uttar Pradesh, when this court held that mere exhibiting a memorandum prepared by the IO during investigation cannot tantamount to prove its content.
Where are you reading?
My lord,
First, Abdul Hafiz had been quoted, then after Subramania. Where is Ramananda?
similar view was taken by this court is in the case of Ramananda Nandi Bharati.
There we go. Yes, 67. Next paragraph.
Yes.
Similar paragraph, page 67.
Similar view was taken by this court in the case of Ramananda Nandilal Bharati.
Just a minute. 67. Have you got? No, those are internal, the internal paragraphs after this 67. 67. Yes.
Similar view was taken by this court in the case of Ramananda versus State of UP, wherein this court held that mere exhibiting of memorandum prepared by the IO during investigation cannot tantamount to proof of its content while testifying on oath. The IO would be required to narrate the sequence of events which transpired leading to the recording of the disclosure statement. If we peruse the extracted part of the evidence of the IO, in the backdrop of the above exposition of law laid down by this court, the interrogation memos of the accused A2 and A1, it is clear that the IO gave no description at all of the conversation which had transpired between himself and the accused, which was recorded in the disclosure statement. Thus, this disclosure statement cannot be read in evidence, and the recoveries made in furtherance thereof are non-estate in the eyes of law. And if we peruse in this present case, your lordship will appreciate this fact. The IO has given effect to certain recoveries in pursuant to the disclosure statement made by the accused person. Disclosure statement, because these arguments should have will be coming from my learned friend, because these disclosures were recorded by given effect by their implicating those colleagues here. So in a nutshell, my lord, the IO who gave the effect, any of the disclosure statement cannot be said to be read as a piece of evidence in view of the judgments of the honorable appellate. Because he have to, what the IO is required to do is that on oath, that yes, on such and such date, the accused was being interrogated by me. On an interrogation, he gave an information which I have recorded it. It has to be in indirect speech that he said to me that if I take him to that place, he can recover that, which has been recorded. In that case, that particular portion has to be reproduced in his evidence, marked it, then whatever the recovery will be coming as a proof. Because exception is there in section 60, which Honorable Supreme Court has said. So if that things holds, my lord, the entire recovery goes away. So what only remains is that the confession statement of a co-accused, as far as I am concerned. Because nothing has been recovered from me. Nothing has been recovered from me. So if the disclosure statements also goes away and only the confession statement of co-accused is there, the lordship is correct, in Kurmi's case ratio will apply to me. Now your lordship will find PW 36.
Is page number?
Your lordship is 237.
Yes.
237 page number, the evidence. Your lordship is there?
Yes, yes.
One of these gentlemen was the first IO of the case of Katichara police station. My lord, on 17/3/2004, I was in Jomila police outpost, patrol post at 7:50 p.m. That day I received information over telephone that Alimuddin Alam, son of Mahmud Ali, a resident of Kilabarg district, saw a motorcycle lying on the side of National Highway 54 while he was coming from Bhairavi on a motorcycle. On receipt of the information, I made a GD entry and proceeded to the place of occurrence along with the staff to investigate into the matter. The GD number is 270, dated 17/3/2004. But this GD entry is not a part of the record. It is CBI has not taken this GD entry on record. Your lordship will kindly come page 238.
Next page.
Next page.
Yes.
In the middle portion, my lord, it starts with the word thereafter.
Yes.
Thereafter, comma, we found the Mahindra jet inside the jungle and also found 2 bags. Recovering some documents inside the bags, I seized the same. As we were making the seizures, SP Hailakandi and CI Hailakandi arrived there. My lord, this seizure list, there is no seizure list of this effect. So evidence, your lordship, eyewitnesses 1, 4, and 5. Eyewitnesses are victim, not implicated in me. No TIP identified by me. Prosecution witness, other IOs also said there is no recovery of me, no disclosure statement of me. Only one, the learned trial court was that the confession statement, which the learned trial court found that all of us are implicating each other, and recovery of the disclosure fact, which I have, lordship, to the best of my ability, I have demonstrated that disclosure statement cannot be read as an evidence because neither it has been proved as per the mandate of the law. So disclosure statement goes away, confession statement of co-accused cannot apply. The last, your lordship, which I would like to kindly draw your attention is that the 313 statement of me, that your lordship will kindly find part 1, volume 3.
Page.
My lord, 618. $635 questions were put to me in my 313. Your Lordship, the index which I have given a black mark, Your Lordship, there are certain questions which I have marked it, Your Lordship. Your Lordship will kindly come to question number 14. Page 623.
Question number
40.
40.
40. PW1 has deposited after they proceeded along the railway lines towards Bhairavi, and one of the motorcycle-borne youths took them to the residence at Rajodari, which was not far from their place. What do you have to say on this? I am not aware of this. I had come from Mizoram on bus on Thursday. On that day, I came to know that Putul Dev had been kidnapped the previous day. On Friday, I had gone to Rajodhal to hand over bamboo to my employer, Rahimuddin. When I reached here at around 8 a.m., I saw Jalaluddin, Tunglung Ali, Konak Sen, Sukur Ali, and some others villagers who told me about the said kidnapping and said that they could not trace Putul Sundar Dev and had gone out and also told me to help tracking him. Thereafter, myself, Konak Sen, Sukur Ali, and Jalaluddin went to one side of the track, Putul Sundar Dev. Jalaluddin has taken us to the place where they were kept sitting during the night of kidnapping. Then we moved forward and saw the footprints on the ground. Jalaluddin said that footprints of Putul Sundar Dev was a bit unique as the sole of his sandal had a wheel mark as it is bought from outside India. Then we crossed a river named Katkal by a country boat. Jalaluddin had called the said boat. After crossing the river, the said footprints of Putul Sundar Dev were again found. We kept following the footprints and Sukur told that in that way we could trace Putul Sundar Dev near a riverlet head. We went 3 kilometers further and saw the same footprints. Thereafter, Sukur Ali told that he did not want to go further. But I told that at Ramanpur, there was CRPF camp nearby and we could inform the CRPF people. Thereafter, Jalaluddin told me that the kidnappers were a strong party and we should not move any further. Then we came back. I came back to my residence and Konak Sen, Sukur Ali, and Jalaluddin went through village Simora.
No, you had said at the outset that some confession of the co-accused has been given to you. Where are those? So
My lord, that I want to point out why I read this question is that PW 29 prosecution witness, he deposed the said fact in his examination in chief as paid 192.
But what about this PW? The question has been framed as these materials are from PW1.
PW1, how can it is not an incriminating fact to me? Nothing has come against me. Otherwise, my lord, examining 35 witnesses, you are putting 655 questions to me.
No, you had said you are not aware of this matter, and there. So where is that thing that the statement of a co-accused has been put?
My lord. Question page 670.
670.
670. Question number 359. The lordship is there?
Yes.
Page 670, question number 359. Your co-accused Sahadev Sakma Ilyas Hurawura in his statement made willingly and voluntarily had stated that he, Krishna Madhav, along with other co-accused, entered into a conspiracy to abduct deceased Putul Sundar Dev for ransom and abducted the deceased Putul Sundar Dev, and after receiving amount of rupees 5 lakh killed him as well as the deceased Nadanand. How can a co-accused statement narration can be put as a question to me? Because that means the learned trial court fundamentally erred that by treating the statement of the co-accused as a piece of evidence. Hello. So, your lordship, so what your lordship I am trying to demonstrate is that the incident which has happened in the year 2004, which was duly registered by the FIR of the family member, there was no headway in that investigation. Accordingly, they approached the High Court in the form of PIL. The direction was issued. When and how, where I was arrested, that is still a question. When the learned judicial magistrate passed the order of my recording of my statement, confession statement, where the recording has been done, and during the statement recording, the learned judicial magistrate could not ascertain the date, time, and where I was being detained. Because if that date and time is been taken, my lord, that goes in a different way. Third thing is that the entire case was based on a confession statement and PIP as reflected in para 6 and the leading to discovery. So learned trial court, what the learned trial court did was that instead of looking into other evidence as the proving of disclosure statement and all, they straight went to the confession statement.
PIP you have been identified.
PIP, I was not identified. Only 4 of the accused persons were identified, but my name was nowhere there. I was not been identified in the doc also. So, the learned trial court, what they did was that, first let us go look into the confession statement. And found that the confession statement is without any duress, it is perfectly recorded under 164, and they are implicating each other. So, to supplement that, went to the PIP that these witnesses have identified, victim and eyewitness and the victim, and went to the discoveries. My argument was that, you cannot begin with the issue of my confession statement or co-accused confession statement. You have to look into the FIR and you have to see what have been affected. That's why I placed the Kurmi judgment, my lord, and the disclosure statement judgment that I have placed. And your lordship will kindly appreciate there's one more judgment of this honorable court. Okay, boss. Para 6, my lord. Section 30 of the Evidence Act provides that when more persons than one are being tried jointly for the same offense, and a confession made by one of such persons implicating himself and some other of such persons is proved, the court may take into consideration such confession against such other person as well as against the person. Para 6.
Yes.
Section 30 of the Evidence Act provides that when more persons than one are being tried jointly for the same offense, and a confession made by one of such persons implicating himself and some other.
This is on the basis of Harisharan.
Yes, my lord. Your lordship will read. What is discriminant from the provision of section 30 is that it merely enables the court to take the confession into account, and how it is to be drawn have received consideration in various judicial decisions. A confession cannot be treated as evidence which is substantive evidence against the co-accused person. Relied upon Harshir and Kurmi. A constant bench of the apex court in the case of Harshir and Kurmi has held that a criminal case where a prosecution relies upon the confession of one accused person against other accused person, the proper approach to be adopted is to first consider the other evidence against such the accused person. This is what I am trying to impress upon my lord. Because the prosecutor has fairly admitted in his argument that my case entirely lies upon the confession statement and TIP. That's why The learned trial court should have looked into other evidences first, then come to a finding that yes, prima facie there is the, let us look into the confession. But you could not do the other way around. That is what I am trying to impress upon my lord.
You have to continue when? Tomorrow? Other councils are there. Mr. Potoki is there.
I have almost completed my lord, my lord. Let my other colleague.
Tomorrow?
Tomorrow.
Let us
Let them complete. I'll do my part on Monday.
Tomorrow, let us complete it. It's
Other things are also
almost 18 years, my lord. We have been trying to hear this matter.
few more days, doctor. Few
Thank
more
you.
days.
Try
Few
to
more
finish it tomorrow.
Yes.
Mr.
Let them
Potoki
complete.
had argued this matter long time back, but it got off listed and there is a change in the bench. So you have to repeat the argument. Okay, tomorrow, huh? Hearing has remained inconclusive. List again tomorrow. ঠিক করে উঠবো বলিব।
If from the date that I am seeking hearing lordship, then apparently I would be eligible to hold the post of joint director as of now, lordship.
That will be
And
beyond the
lordship,
scope of.
under the rules, lordship, they require a list of candidates to be prepared and sent to the commission for lordship for appointment, promotion, lordship. But that they
Now you
have
have to make out a case of discrimination. That you were left out, somebody else were given.
no. I am relying upon this decision, lord.
Which one?
This is an NR Banerjee lordship, wherein it has been stated that lordship, if there is a requirement under the rules for a checklist to be prepared and a panel to be prepared, and that is to be done yearly, that has to be followed, lordship. Otherwise, there will be anomaly, lord.
Now, has anyone been given the benefit of promotion?
Yes, lord.
Who?
Lordship,
Who is not eligible?
who is not eligible?
Yes.
Lordship, apparently in respect of Parthapratim Sharma, lord, Parthapratim Deva Sharma,
Yes.
lordship, he was given promotion to the post of joint director, lordship, by relaxing the rules, lord.
Joint director is
2025.
beyond the purview of your prayers. Parthapratim's name has come
I am
recently.
seeking a similar relief.
The Parthapratim has been given in respect of deputy director and promotion to post of promotion to regarding minimum requirements. This Parthapratim has been given only in 2024.
To the post
October.
of joint director in 25, lord.
Yes.
And it was done by relaxing the rules, lord. So I am seeking a similar relief, lordship. Because the post are vacant, lord.
Joint director are part of the relief. Let us see.
So my relief is to the extent that my promotion be given to the post of deputy director with effect from 15/11/2013.
Then we cannot go to the
Lordship, because the writ petition was,
you make a fresh writ, we'll consider, not in this.
lordship, at least the consideration to the effect, because
Under
under the
which
rules,
prayer? Show us the prayer. Without a prayer.
lordship, that date, lordship, I am
Without a prayer.
to the post of deputy director, lord.
Deputy director will consider. We'll see the reasons. We are more on the discrimination part. They have shown some reason, whether those reasons are sustainable in law, we'll see.
Lordship,
That you were left out, somebody else was given. Ideally, you should have been considered and given, but they have cited certain reasons.
yes, lordship, but then I would like to say, lordship, in 2004 itself, lordship, they say that,
You came in 2017.
yes, yes, lordship. That was to the post
See,
of
it's very
deputy.
easy to argue, but if we confront you with question, you don't have any answers.
My
We're trying to
claim,
consider your case.
prayer
You
number
came to the court after 13 years. If you go back to 2004, what were you doing in 2004? Do you have an answer? You don't have an
My
answer.
representations were pending and they, in their
Representation
affidavit,
will enlarge your cause of action.
Lordship, they have in their affidavit stated that, Lordship, while
We are very interested to see whether somebody else has been given by leaving you. That is not the case.
Lordship will kindly turn to their affidavit, Lordship, once.
Page,
Internal page 4, affidavit filed by the respondent number 4, Lordship.
yes,
Paragraph 10,
paragraph 10, yes. Paragraph 10,
yes, Lord.
in Bimal Kaur's case.
Paragraph
Paragraph 10.
The last 3 lines, Lordship.
By who? Pallab Jyoti Nath. Pallab Jyoti Nath.
From Komala Kanto Sharma, Lordship. Kanak Chandra Sharma, Lordship.
In Bimal Kaur's case, let me check. Kamal, yes, Kanak Chandra, it's page 33.
Lordship, paragraph,
By R4.
paragraph 10,
Para 10.
I'm reading the whole of it, Lordship.
Just
That-
a minute, just a minute. Yes, please read.
That with regard to the statements made in paragraph 6 of the repetition, it is respectfully stated that the first amendment process of Assam Forensic Science Laboratory Service Rule 1985 was continued till 2003, and during that time promotions were restricted and normal promotion process started in 2006 for few posts of Directorate of Forensic Science Assam, which also includes one post of scientific officer, in which Bimal Kaur got promoted to scientific officer. Final gradation list of scientific officer was published in April 2000. This ought to have been 2012, Lord. And the revised promotion proposal for the promotion to the post of senior scientific officer from scientific officer was submitted to government in October 2012, and subsequently Sri Kaur, the petitioner, got promoted to senior scientific officer on 26 2013. Lordship, then Sri Bimal Kaur will be eligible for promotion to deputy director after completion of 5 years as senior scientific officer. So, Lordship, after that 5 years, he was never considered, Lordship, and it was only in 2023 was considered, Lordship. So they did not keep the statements made on out, Lordship. That was filed in 2001.
The affidavit says that you will be eligible for promotion. Where is the commitment that will be considered and promoted?
Lordship, there were vacancies available, and I am relying upon this decision. Lordship, can you tell it once?
Yes. Citation.
Lordship, I take it. It's been taken from SCR, Lord. So the judgment and order dated 14/8/1996.
Should have a citation at least.
So I'm giving the citation.
Which paragraph?
Lordship, hearing the consideration of the tribunal would be necessary to understand this case. Lordship will kindly turn page 169, Lord. The last paragraph.
Yes.
Rule 2.1 relates to composition of the DPC for Group A and Group B officers. Member included in DPC to 3 officers who are at least one step above the post in which promotion confirmation is to be made as indicated therein under. This is consistent with the law laid down by this court in State Bank of India and others versus Kashinath Seth and others 1996 8 SC 67, where it was held that the object of writing a confidential report is twofold, that is to give an opportunity to
This is not the ratio you're trying to rely. Which paragraph?
otherwise the tribunal's direction was upheld, Lordship. That Lordship will find at page 174. Wait, wait. No. Nineteen 97 9 SC 287 is the citation. 1997 9 SC 287 is the citation, Lordship.
2 SCC.
Yes. And
287.
287. Lordship, page 173, the whole paragraph is relevant, Lordship. And here in the directions passed by the tribunal was also reflected, Lordship.
Which 173?
Page 173, the not the two lines, Lordship, thereafter, Lordship. Considered from that perspective, the question arises whether the view taken by the tribunal is justified in law. It is true that filling up of the post are for clear or anticipated vacancies arising in the year. It is settled law that mere inclusion of one's name in the list does not confer any right in him or her to appointment. It is not incumbent that all posts may be filled up, but the authority must act reasonably, fairly, and in public interest, and omission thereof should not be arbitrary. In so and so, the Constitution bench had held that inclusion of name of a candidate in a merit list does not confer any right to be selected unless the relevant recruitment rules so indicate. The state is under no legal duty to fill up all or any of the vacancies, even though the state acts in arbitrary manner. In so and so, it was held that mere inclusion of one's name in the panel does not confer on him/her any indefeasible right to appointment. It was further held that the purpose of making panel was to finalize the list of eligible candidates for appointment. The preparation of panel should be to the extent of the notified or anticipated vacancies. Unduly wrong panel should not be prepared. In so
Operated.
Lordship?
Operated, not prepared.
Lord.
Operated.
Operate. In so and so, it was held that the mere fact that candidate's name finds a place in the select list as a selected candidate for appointment to a post does not confer on him/her an indivisible right to be appointed in such post in the absence of any specific rule entitling him to such appointment. In so and so, it was held that a person who is selected and empaneled does not, on account of empanelment alone, acquire any indefeasible right to appointment. Empanelment is at the base a condition of eligibility for the purposes of appointment, and that by itself does not amount to selection or creation of a vested right to appointment unless relevant rules state to the contrary. However, in the light of the above principle and in the light of the clear rules extracted herein before, it is seen that the exercise of preparation of the panel is undertaken well in advance to fill up the clear vacancies or anticipated vacancies. The preparation and finalization of the yearly panel unless duly certified by the appointing authority that no vacancy would arise or no suitable candidate was available is a mandatory requirement. If the annual panel could not be prepared for any justifiable reason, year-wise panel of all the eligible candidates within the zone of consideration for filling up of the vacancies each year should be prepared. An appointment made on in accordance therewith. In so and so, this code had pointed out with respect to the prescription of the limitation of 1 year of the waiting list does. The reason underlying the limitation of the period of list for 1 year is obviously to ensure that the qualified persons are not deprived of the chances of applying for the post in the succeeding year and being selected for appointment. It is true that the material furnished before us would indicate that action was taken on December 22, 1993 by the Ordnance Factory Board and circulated by the action to be taken by the government, and thereafter the Union Public Service Commission was consulted. Action taken on this material should have been taken much earlier to the date on which it was taken, since they knew that 4 members were due to retire in August, September, October 1994 and March 1995. These were anticipated vacancies likely to arise on permanent basis, and promotion to them was to be made on regular basis. In other words, they were all clear vacancies. So they were to be finalized before April 1994, and the confidential report should have been approved before 31st March 1993, and all eligible candidates within the zone of consideration as on the date of DPC were entitled to be considered. The direction given by the tribunal referred to above is clearly in accordance with the procedure indicated herein before, and therefore we do not find that the orders are vitiated by any error of law warranting interference. The appeals accordingly dismissed. This was appeal preferred by the Union Law. So the order of the tribunal, wherein lordship there were anticipated vacancies that was directed by the tribunal to be filled up with, and a panel was to be prepared in that year itself. The council before the tribunal for the union stated that that I wanted to show lordship. Lordship, page 168.
168. Yes.
On this factual matrix, it is contended by the appellants that the crucial date for the DPC meeting for selection should be April or May 1995 for selection of candidates to fill up vacancies of the year 1994-1995. The ACR's recorded of all the candidates falling within the zone of consideration and approved by the government as on March 31, 1994 are required to be looked into and merits adjudged. The tribunal therefore was not right in, this was the statement made by the union. The tribunal therefore was not right in directing the government to ignore the ACRs for the year 1994 and consideration of the candidates eligible by them up to March 1993. The DPC was to be constituted as on April 1, 1994. Resultantly, the direction was given in paragraph 25 and 28 of consequential action. Sri so-and-so learned additional Solicitor General contends that the view of the tribunal is not correct in law. As per the procedure, preparation of panel of candidates for consideration by the DPC to fill up the clear vacancies as on April 1994 is necessary. ACR are prepared on the basis of performance during financial year which would be October 1 of the year. In this case, the ACR of the incumbents are written on the financial year basis. It was approved by the government in March 31, 1995. Therefore, the DPC could not have got approved ACRs before the date, namely as held by the tribunal on March 1993. The direction, therefore, that the DPC in its proceeding should take into consideration ACRs of all eligible candidates as on April 1993 is incorrect. Though prima facie we were impressed with the arguments of Sri so-and-so On deeper probe and on going through the procedure laid down by the Ministry of Personnel and Training, we find no force in the contention. Preparation of the action plan for consideration by the DPC of the respective claims of the officers within the zone and thereafter for setting in motion the preparation of panel on year-wise basis is elaborately mentioned. It is in case of their failure to do so, what further procedure is required to be followed is also indicated in the rule. It thereby
In
may
our case, what are the rules?
Lordship. Yeah, next question.
What is the consequence of not preparation?
Lordship. Rule 12,
Page?
I'm giving the rule first.
Yes.
12, Lordship. Promotion to other cadres. Subject to suitability.
Yeah, that is the promotional ladder, how the preparation of
Rule 11 or 13. Rule 13, Lord.
1-3.
Yes, it's a rule 30. Rule 13, general procedure of promotion has your lordship.
Yes, yes.
Number 1, before the end of each year, the appointing authority shall make an assessment of the likely number of vacancies to be filled up by promotion in the next year in each cadre.
No,
Now,
this is there in all rules. Where is the consequential part? Which was
Lord,
there in the
the whole of the rule is the one provision cannot be read in exclusion of the other, Lord. So the whole is relevant, Lord.
no, whole is relevant. No, in the case before the Honorable Supreme Court,
Lord.
there was also a provision that if you do not follow the rules, there is a consequential provision.
Now, in these rules, Lordship, if suppose they do not fill up the vacancies, Lordship, then the list that was to be prepared, that herein also it has been said that it's mandatory required. That was to be prepared, and those vacancies, in case they do not fill up, that will be carried forward.
No, after 1 year, the selection goes, vitiates.
No.
After a year, if you even prepare a list,
Rule
it cannot
8,
be.
Rule 8, Lordship, 13 Rule 8.
Yes. For 12 calendar months. After that's gone. So if they're not promoting, what is the academic exercise of preparing a select list? And we are more interested in this part where consequence has been also laid down in the rules if you do not prepare.
Lordship. Come to that. Provision wherein the same process was to be repeated.
In
Lordship.
case their failure to do so, what further procedure is required is to be followed is also indicated in the rules.
Lordship, this rule has undergone an amendment in 2003, Lordship, and this Rule 13, I'm forwarding the amendment. Lordship. I think of overall seniority. 13. Lordship, herein the amendment was that the overall seniority was to be counted, Lordship. And overall seniority, I would say that I had served for from yes, I am eligible. No. Now, Lordship, what had happened is I am the senior most among those, Lordship. And if a promotion is to be made to the point of joint director, Lordship, I am to be considered, Lordship. And apparently, Lordship, I was, although others have been considered, Lordship, my consideration was not made by relaxing the rules, Lordship. So, due to that, Lordship, I have been deprived of a number of occasions.
Senior most in from the point of view of total length of service,
Yes, Lordship.
not in the feeder cadre.
No,
Cannot be.
Mona Lisa Toduri was
Bimal Bormon.
in the feeder category. Yes, Lordship. Therein also I am senior.
You meet the eligibility criteria
Yes.
in the feeder cadre.
Now, for promotion to the post of joint director,
How many years are required?
10 years in total as deputy director is required.
10 years as a deputy director.
Ten-
Not 10 years, I think.
5 years.
5 years.
Sorry, Lord.
5 years.
5 years.
Have you done 5 years?
Because I was holding the charge, Lordship, since 2016. And the posts are vacant, Lordship, otherwise. And if they say that they do not need anyone, Lordship, and they do not want to fill vacancies, they need to say that, Lordship, after preparing that panel, Lordship, in terms of this judgment.
No, after you prepare a panel, if you don't intend to fill up, why do you prepare the panel?
Lordship, that's what the judgment says,
It
Lordship.
cannot be a mere academic exercise. And the select list gets, the validity expires by 12 months.
Lordship, let them show, then they have prepared a list, Lordship. Otherwise, that is a requirement under the rules.
So,
Lordship.
Sharma, we are on the substantial relief if you are getting something. It's not a ego fight. I'll be satisfied if the list is prepared.
Oh, Lordship, the agony is
What
that
do you get? Let us see if you can get something substantial, which will really benefit you. You get a list into your hand, no promotion. Will it help you?
Lordship, otherwise.
We are not endorsing the views that they can ignore what is mandated by the rules. We are not endorsing that. But how do you expect us to give the relief which you are claiming?
At least a consideration, Lordship, in terms of these rules itself, where it says that yearly that consideration.
Where is the relaxation part again? Rule?
Rule 28, Lordship.
What can be relaxed?
Requirement of that 5 years.
Now let us see the wording. What can be relaxed?
Lordship, where the government is satisfied that the operation of any of these rules causes undue hardship to any particular case, it may dispense with or relax the requirement of that rule to such extent and subject to such conditions as it may consider necessary for dealing with the case in just and equitable manner, provided that the case of any person shall not be dealt with in any manner less favorable to him than provided in this rule. Lordship, one Partho Putin Devasarma was promoted director in 2025, and that was done in relaxation of the rules. So, similar benefit.
Even your client has got with Mona Lisa.
I am claiming in respect of Bimal Kuala. He did not get it.
You are also espousing the cause of one of the same beneficiaries.
Yes, sir. But then she was eligible because she has served for 29 years.
And we asked Mona Lisa to be also brought down along with Partha Protein, all at par.
Lordship,
You cannot make two arguments.
in this case, Lordship, and since I am representing both the petitioner, I could vote favor. But then,
Okay. Mr. Goswami, anything?
Yes, my lord, the Malkor case is entirely based on, my lord, allegation that 3 persons were relaxed in respect of giving promotion to the post of deputy director. That is why, that is the only basis they sought for, my lord, direction of this honorable court, my lord, to consider their case. Although this may not be relevant to consider, my lord, the prayer of the petitioner, just I am pointing out, my lord, as I have already pointed out, my lord, till 2006.
It was based on the foundation, so-called foundation, that you had given benefit to 3 persons by
Yes,
relaxing the
that
rule.
is their
By
foundation.
relaxing the rule. This is not factually not correct.
Absolutely incorrect. This is the only, my lord.
no,
Only
Lordship,
basis.
I will say, put it
No,
like,
And now they have enhanced to the extent of the post of, my lord, deputy joint director.
These 3 persons against whom allegations are
Yes.
there, they were given promotion in due course.
Yes, only after completion of 5 years. Government did not consider relaxation, my lord. Their proposal was there 4 months ahead, my lord. The proposal was submitted, but government did not consider. Government gave promotion only after completion of 5 years. My lord, during 2004, there were only 2 scientific posts of scientific officer.
In 2004.
2004. So directorate proposes to fill up the post, my lord. Since 50% has to be filled up through direct recruitment and 50% through promotion.
Hmm.
And one post, that is till 2006, my lord, government restricted the promotion, my lord. Maybe in view of the fact that the matter was dealt with by this honor. That may be also be current, because all these things were not explained. That is why I am not going to say, my lord, much on that. And my lord, so 2006 itself, my lord, the case of the petitioner was considered. In fact, he got the benefit at that time, my lord. He first, during the entry into his service, my lord, the benefit of STP. I think nowadays he is not STP, but because of the promulgation of that ordinance, my lord, giving six communities as STP, subsequently in the parliament, it was lost, my lord, as your lord will remember. That benefit he was given in spite of the fact that his position was 4th, my lord. He was given promotion and one was appointed to direct recruitment. That is 2006. Then, my lord, 2012. 2012, the cadre of scientific officer was prepared, my lord, and submitted. And immediately thereafter, on 12th, then, my lord, he was promoted in the year 2030, based on the gradation list prepared during 2012.
This Bimalkar promoted to scientific officer.
Yes, that is 13 senior scientific. The gradation list is of scientific officer. Promotion was to the post of senior scientific officer. In 2015, proposal was submitted to the government for giving total 25 of posts, including two posts of deputy director. But government allowed only 22 posts. That 2 posts of deputy director are not connected with the department of the petitioner, because that was holistic, I think, one, and one is physiology. And he is, my lord, toxicology. Toxicology post fell vacant 2016 on retirement of that Samudra, my lord, that, yes, Boishya, my lord, Samudra Boishya, he has alleged that he was given a relaxation, my lord.
Toxicology Deputy Director post.
Yes, that was only fell vacant 2016.
Yes.
2015, my lord, two posted here, my lord, deputy director,
Hmm.
vacant. Government allowed to fill up two posts, deputy director. One seriology, one ballistic, I think, if I'm not wrong. And my lord, 2006, he has got promotion to the post of senior scientific officer only in 2013, my lord.
Yes.
So 5 years is 18, my lord, he is eligible. We have also stated in our affidavit, he is eligible. 18, he is eligible. But the department cannot wait for a long time. There is provision in absence of promotees, my lord. Government has to go for, my lord, direct recruitment. Certainly, government took step. That statement is also not there, my lord, in respect of the petitioner. They have not stated anything with regard to the same. That is why also, my lord, affidavit is also limited to certain aspects. Not explain everything, my lord.
Did you make direct recruitment?
Perhaps, my lord, 2016. And when the vacancy fell vacant, my lord, 2023, my lord, immediately he was given promotion to the post of deputy director.
No, no. The advertisement is there, Lordship, at page 30, Lord. That was the procedure undertaken.
So that is why, in absence of persons holding the post of senior scientific officer to get promotion to the post of deputy director, then other provision is to go for
In 2023, the vacancy arose in toxicology.
2000,
23?
23, not 2016.
No, 23. The
Yes,
Deputy
yes,
Director
yes.
toxic,
Yes.
and
Because, my lord,
he has been promoted to the
yes.
post.
My lord, because nowadays, my lord, because of the direction of this honorable court, perhaps, my lord, all deputy directors are treated equally. Earlier, my lord, division-wise seniority was counted. That is was no reference was there here. But 2016, my lord, that is why, my lord, while he was working as senior scientific officer, my lord, he was allowed to look after the department.
What are your affidavits?
But the affidavit is limited to that aspect only.
Who has filed affidavit?
My lord, it is deputy director, my lord. Sorry, director.
Kanak Chandra Sharma?
Yes, yes. And thereafter, government also filed an additional affidavit, my lord, indicating the promotion of the petitioner to the post of deputy director. One is regular affidavit, another is, my lord, additional. And no point of time petitioner alleged that someone has been promoted, ignoring the case of the petitioner. Post third year, all are blanket, nothing was specific, my lord. This is the reason because I was deprived of, nothing is there. Only their cases, 3 persons were granted relaxation, they were given promotion. It is absolutely incorrect. And based on, they are also seeking relief.
Where is the statement? 3 persons?
Yes. All along they are saying, my lord. Yeah. Paragraph 13, my lord. Page 10. The petitioner states a similarly situated person whose promotions were delayed by the respondent authorities were granted relaxation in the manner of promotion in the cadre of deputy director. However, the same yardstick is not being applied to the case of petitioner, which is clearly discriminatory, illegal, and arbitrary. The action of the respondent authorities is violative of established principles. As such, it is a fit case where this honorable court shall be pleased to intervene into the matter, issue of appropriate direction, in exercise of its power under Article 226 of the Constitution of India in order to give just, fair and equitable relief to the people. This is the final statement. So with this, I think I can conclude my submission.
Just a minute. Paragraph 5 is more important, not 13. Names are also there.
Yes. Samudra Gupta Tilak, 2022.
Because 13 you have not replied. There is no reply of 13, but there is a reply of 5.
Yes.
Yes, okay.
On this count only, the petition is liable to be, my lord, dismissed. And in our affidavit at paragraph 9, my lord, we have categorically mentioned.
Okay.
Lordship, at page 28, Lordship may kindly peruse paragraph 8.
28. 28 is what?
It's a representation. Herein, Lordship, the file, relevant file with regard to the promotion of Samudra Vaishya, Tilaka Das and Pujati Hazarika is referred to, Lord. File number HMA 29, 2010, that's 58. Lordship, our allegation was that prior to completion of the period of 5 years, their names were sent to the Home Department, Lordship, for promotion, Lord. So apparently relaxation was given to them.
It has been denied on affidavit.
Denied.
Where is your averment in the petition regarding that file? You have only made a mention at page paragraph 5 and paragraph 6.
But this file number would clearly show, Lord.
No. Where have you stated in your affidavit, in your petition?
With regard to that relaxation.
No, regarding this file, they were considered in this file.
Oh, no, Lord.
Why? If you could mention it in your representation. And there's a denial. There is denial by the department.
Lordship
5
will
years,
kindly
few
turn,
months. Only after completion of
Lordship
5
will
years and
kindly
few
turn
months.
to page number 3 of the affidavit filed by that KC Sharma, Lordship. Paragraph 9.
Yes.
With regard to the statements made in paragraph 5 of the writ petition,
Yes.
it is respectfully stated that Sri Samudra Vaishya, Dr. Timothy Tilaka Das, Dr. Drupadi Hazarika joined as Senior Scientific Officer on 38,008, and the norms for promotion to Deputy Director in MSc with position of 5 years continuous service as Senior Scientific Officer on the 1st January of the year of promotion, as per their promotion proposal was submitted to government on 28/1/2013, and they got promoted to deputy director on 15/11/2013. Lordship,
years.
proposal was sent earlier, Lordship.
5 years.
No, they did not complete 5 years.
No, on the
They would have
first,
completed on
continuous service on first of January,
And
2005.
my lord, just specific statement. In spite of that, why my learned pen is referring to, they got promoted to the director, to the deputy on 15/11/2013. That is 5 years, I think 4 months.
anyways, Lordship,
Proposal was submitted earlier to that. That is correct. That has not been denied.
although
But government, my lord, appropriate authorities in the government
Okay.
considered and promoted only
Heard.
after completion of 5 years.
Lordship, one more submission. Lordship, apparently in my prayer, Lordship, I have prayed claim against that post of deputy director with effect from 2016, 2000. No, 2013, Lordship. 15/11/2013, prayer number C, Lordship, page 12.
Hmm.
Now, his promotion was given in 2023, Lordship. Apparently, there is a delay.
No, you read the entire prayer. In terms of the retrospective effect given to his promotion to the cadre of scientific officer, you want to give retrospective promotion is permissible.
Lordship, they have relaxed it anyhow, Lordship, because in case of Partha Pratim Devasarma, Lordship.
This
that-
we have already considered.
Yes, Lordship.
One of the petitioners also got the benefit. Will say
Yes,
something.
yes, Lordship.
Heard. So naam likhiba, huh?
There is a delay of 10 years. That's what I wanted to put.
In so and so, and heard also heard Sri B. Goswami, learned AEG for a department. Mr. Datta, you also. You are what? APSC, standing counsel. AP Datta, APSC. In one of the items.
Yeah.
Okay. In WPC so and so, hearing is concluded, judgment is reserved. Okay, we'll consider.
Obliged.
Lordship, in respect of Mona Lisa Chaudhary, I prepared a list, Lordship, list of dates for this one, Lordship. And Lordship, may only have a look at it on the date when she was eligible and when she got promotion, Lordship.
My lord, that consideration note better.
I'll have to, we'll retain this. Do you have a copy?
Yes, I have.
We are retaining this.
Yes. Obliged. Good.
You want to see? This, what is this?
Lordship, one was what that creation of that post, Lordship, and the other was judgment. In the list of this.
My only humble prayer to promote the my place the deputy director.
Need to have this before the public measure. Uncle hate audible. Yes. Why are you waiting, Mr. Karan? Which matter? Review matter. Other side, if we have the time, you. No, what is that matter? No, if the other side is there, we could have given preference to your matter. Otherwise, we'll fix a date. What is the reviewer seeking?
This is not
No? Yes.
It-
sir.
a small tactical issue, Lord. Peruse page 24, Lordship, that order is not to be reviewed, Lordship.
24.
Lordship. And property part is 20, it starts from 25, Lordship. Lordship, Lordship, okay.
who has filed a petition under section 115 for just article against the common judgment and order dated just passed by the learned district judge Kamrup Aminggaon
Yes, yes.
Lordship.
No, yes. So what is the review are seeking?
No, Lordship, that Lordship held that under section 54 appeal lies,
Yes.
but appeal lies only when you challenge the award. Here, a preliminary issue is raised by the petitioner, IIT Guwahati, that IIT Guwahati should not be made a party, its name should be struck off. That preliminary issue, that application is taken up at the final hearing of the matter. The award has been enhanced, we have no objection against the award. But in the preliminary petition,
But the reference has been answered in 23 to 2024.
Lordship,
Reference has not been answered.
No.
Is the reference answered or
it
not?
will be answered that,
If it is answered, 54 is the remedy.
no, 54 is, Lordship will kindly read. I just,
No,
I'm reading 54, Lordship.
Yes. No. Land Acquisition Act, 1891. Please read.
Lordship. Appeals in proceedings before court, subject to the provisions of the Code of Civil Procedure, just applicable to appeals from original decrees, and notwithstanding anything to the contrary in any enactment for a time being enforced.
Yes,
And appeal shall lie, appeals shall only lie in
yes,
any proceeding under this act
yes,
to the High Court from the award
yes,
or from any part of the award.
yes.
We are not challenging the award. Award, it is enhanced, no problem. Central government will look after it.
Yes.
But additionally, the reference court said that IIT Guwahati is a necessary party and IIT Guwahati will,
It's a part of the award.
no, then they said that IIT
It's
Guwahati,
isn't it a part of the common judgment 23 to 2024?
no, it's a common judgment or that hell, the IIT Guwahati will make payment of the award within 2 months. Whereas our,
No, you have to, what is the difficulty in preferring an appeal? Under 54. You
that,
have a right to appeal, statutory right to appeal. Himalayan Tiles, Supreme Court has said recognize your right. Even our full bench, Sohan Lal Pugalia. It's
Is that-
settled. Third party rights are recognized when you are a party interested, subject to the provisions. So,
which we are not challenging the award. That is
no, it's a part of the award. You cannot just
as you Lordship holds that, then no, we could do it. That is the case.
Third, Sri Arpika Kotil and Senate Council, assisted by Sri A.K. Datta, for the applicant who has preferred this application, praying for review of the order dated 21/6/2024 passed in CRP 66 of 2024 full stop by the, and it is submitted that it is only a part of the award by which the applicant was added as a party, which was thought to be challenged. Full stop. The aforesaid submission has been considered. Full stop. For ready reference, the order sought to be, for the order in respect of which review has been sought is reproduced herein below, 21/6, page 25. Para. The application, which was registered as CRP 66 of 2024, was preferred against the judgment and order dated 23/2/2024, passed by the learned district judge in 2 reference cases, which were made under Section 18 of the Land Acquisition Act 1984. Full stop. The Act itself specifically provides for appeal in the form of Section 54, which reads as follows. The Honorable Supreme Court, in the case of Himalayan Tiles versus so-and-so, has clearly laid down the right of referring an appeal even to a party for whose benefit the land has been acquired. In fact, and following the said decision, this court, a full bench of this court has also reiterated the said proposition. Full stop. In view of in the case of a full court, in the case of so-and-so, in view of the above, this court is of the opinion that no case for review of the aforesaid order is made out, and accordingly, the instant application is dismissed. There's another provision. Yes. Okay.
But delay Lordship in appeal, can there be any observation Lordship that filing the appeal, some delay had occurred?
You can take up that aspect in the delay condonation. Otherwise, it's a first appeal. You'll go by the Limitation Act. You take up this issue. You can get 14 benefit if you plead Section 14 Limitation Act.
Oblige.
Yes, full code is Sohanlal Pugalia. I forgot the citation. Sohanlal Pugalia. Yes. Item?
Oblige. Deeply obliged.
Yes. Item 2. Yes.
Lordship. Lordship, herein, Lordship, there is an error in the synopsis. If there is an error in the synopsis, that is stated in the synopsis that this is against an order of suspension. Lordship, this is basically against an order of penalty imposed upon the petition. Lordship, the petitioner.
Other matters may not be possible, Mr. Dotto. We'll have your date, Mr. Chotia. Have a date.
The petitioner herein was serving as a constable under CISF. But at the relevant point of time in the year 2018, Lordship, he was posted at NRL Numaligarh.
2018.
2018, Lordship. More particularly on 11th of April 2018.
Posted at NRL.
NRL, Lordship.
Okay.
Now, your Lordship, I kindly come to the memorandum of charges, Lordship, at page 18.
18.
18, Lordship. This is dated, Lordship, 2nd of May 2018. May I read it, Lordship?
Yes.
Number so-and-so Constable G.D. Ratul Bora, that is the petitioner herein, of CISF Unit NRL Numaligarh, is hereby informed that it is proposed to take disciplinary action against him under Rule 37 of CISF Rules 2001. A statement of allegation of which action is proposed to be taken as mentioned above is also enclosed in Annexure A to this memorandum. The petitioner is hereby given an opportunity to make the representation if he wishes to make it against the proposal. Now, your Lordship will come to the charges at page 19.
Yes.
Article of Charge 1. On 11/4/2018, CISF number so-and-so Constable G.D. Ratul Bora of CISF Unit NRL Numaligarh indecently behaved with female nursing staff
and general duty staff of BK NRL Hospital and locked 4 female medical staff inside the vaccination room. Medical superintendent tried to pacify him, but he argumented with him, and for this reason, medical works got hampered. Further, he threatened the medical staff of BK NRL Hospital that he will make this an issue in front of the media. Being member of the force, such activities are not expected. The above act amounts to gross indiscipline on the part of the petitioner, hence the charge. Thereafter, Lordship, the Article 2 charge on similar lines, Lordship. On 11/4/2018, CISF number so and so, Constable Jidi Ratulpur of CISF Unit NRL Numaligarh indecently behaved with female medical staff and medical superintendent in BK NRL Hospital, which is a common public place, and forcibly locked 4 lady medical staff inside the vaccination room, which has tarnished the image of the force. The above act amounts to gross indiscipline on the part of number so and so Constable G.D. Ratulpura. Being member of the force, such activities are not expected, hence the charge. Now, in response to that, I had submitted my reply on page 20, that is dated 5/5/2018, wherein I had sought for a few documents, and I had made a prayer that a regular inquiry be conducted as per Rule 37(1)B of the CISF rules, so that I am given a result.
Page 20 is what is the date?
Page 20 is 5/5/2018.
Where do you get the dates?
At the bottom it's there. I have also made it stated in my paragraph.
Bottom where?
Kindly paragraph 10 I have stated, Lordship.
Where is the date here? No date. Page 20, request to provide documents.
Request to provide documents and for conducting a regular inquiry, Lordship, in terms of Rule 37(1). That is at paragraph D of the letter.
Inquiry, okay.
But I had made that prayer on account of the fact that since.
Okay, thereafter.
Lordship, thereafter, your Lordship may kindly come to page 21, the next page. This is dated 9th of May 2018. Now, this request, may I read, Lordship? This disposes of a representation dated so and so, memorandum of charge dated so and so. Constable G.D. Ratulpur of CISF, who has been dealt under Rule 37. The charged official has been given full opportunity in defense to defend the allegation of charge with direction to submit his representation. Now, paragraph 2, Lordship. The undersigned, being disciplinary authority, meticulously gone through the relevant points averred in the application and decided that access to official documents in connection with minor disciplinary proceeding as requested by the charged official cannot furnish. The disciplinary authority does not desire to conduct detailed inquiry as it.
Yes.
Therefore, Lordship, my prayer to conduct a detailed inquiry so that I am giving an opportunity to cross-examine the witness and produce the documents.
Where are the rules?
Lordship.
What is the minor penalty procedure? What is the major penalty procedure? No. Yes.
It may kindly come to page 24 of the rules.
24. Rule number?
Rule number 37, Lordship, which they have relied upon.
Minor penalty, yes.
Procedure for imposing minor penalty.
Yes.
No order imposing any of the minor penalties specified in Rule 34 shall be made except after. Clause A, inform the enrolled member in writing of the imputations of misconduct or misbehavior on which it is proposed to be taken and giving him a reasonable opportunity of making such representation as he wishes to make against the proposal. B, holding an inquiry if the disciplinary authority so desires in the manner laid down in sub-rules 3 to 20 of Rule 36. C, taking the representation, if any, submitted by the enrolled member under Clause A and the record of inquiry, if any, held under Clause B into consideration, and Clause D, recording the findings on each imputations of misconduct or misbehavior. So therefore, I have made a prayer that in terms of Rule 37B, a regular inquiry may be conducted. So that because the allegation was that I had misbehaved with a few medical nurses.
What is the ultimate penalty which has been given?
Lordship, ultimate penalty is reduction by 1 stage for a period of 1 year.
Cumulative effect.
No, Lordship. It says that without cumulative effect, and it will not have any further. It won't hamper my future.
How do you claim as a matter of right that an inquiry has to be conducted? It is up to the discretion of. In fact, minor penalty procedure can be converted into a major penalty. Then the holding of inquiry becomes mandatory. But if they are sticking into imposing a minor penalty, which culminates into a minor penalty, then as a matter of right, can you claim?
No, Lordship, as a matter of right, I cannot claim that they should conduct a regular.
Then if you cannot claim, then you have to challenge the virus of this requirement of these rules. That even for minor penalty, the rules contemplating that no inquiry may also be there, that is bad in law.
But
if it's a part of the rules, and these rules are parametered in all central government organizations. If you compare with all central banks, the PSUs, this is there.
What I beg to submit is that I cannot ask them to conduct a regular inquiry. It's up to the discretion of the authority. But Lordship, at least there should be some reasons why this inquiry cannot be conducted, because Lordship, I'm relying
No, it's
upon
not required. If the ultimate outcome is a minor penalty and the rules allow that, or if it is a case that even a so cause was not given to you, then there would have been a case of violation. Now, unless you can successfully challenge 37B or 37 for that matter, because B is a one-way traffic, its discretion is upon them. If B would have said that if you request, they are mandated to hold an inquiry, and in spite of that, it's not held, the matter would have been different. Now, we are not even asking you the effect of the penalty. It's not with cumulative effect, but still, then stigma may be there. You can still argue that stigma was there, though practically it has got no effect. Is it hampering his promotional aspects?
No, already, my lord, I have, because of that minor penalty, my STR grading has been recorded as average, and on that count, MSCP has been denied.
No, SCR has got nothing to do with minor penalty.
No, Lordship, in their written statement, they have stated that since this minor penalty was imposed, my recording was rated as average, and therefore MSCP has been denied.
This ground which you are trying to urge would not be available, but you will still be, it will still be open for you to argue this case on different grounds, but not on the aspect of holding a full-fledged inquiry.
On that,
and if that goes, we come to a total domain of factual metrics. It will be difficult for this court.
I understand. If I am only relying upon an OM of TOPT at page 63, wherein it has been stated that
63.
Page 63. Certainly, what has fallen from your Lordship, I cannot.
63.
Lordship.
Yes, please.
Paragraph 2, 10th line, Lordship.
Just a minute. 63. OM dated 28/10/85. Yes, what is it?
Paragraph 2, Lordship, 10th line in the middle, Lordship. In a case where a delinquent government married.
Yes.
In a case where a delinquent government servant has asked for inspection of certain documents and cross-examination of prosecution witnesses, the disciplinary authority should naturally apply its mind more closely to the request and should not reject the request solely on the ground that an inquiry is not mandatory. If the records indicate that notwithstanding the points urged by the government servant, the disciplinary authority could, after due conclusion, come to the conclusion that an inquiry is not necessary, it should say so in writing, indicating its reasons, instead of rejecting the request for holding inquiry summarily without any indication that it has applied its mind to the request, as such an action could be constituted denial of natural justice.
Why is it marked to Ministry of Agriculture? Why?
The original is
number 2,
page 64.
Yeah, that is also agriculture is there. Number 2. Serial number 2. Original or type same. Ministry of Agriculture, why only?
The original is at page 64. Therein also the same typographical error is
that
there.
is what we are asking.
But the same typographical error is there. Therein paragraph 2 has been written twice.
No, we are not on the number. We are on the what has been written, the contents. Ministry of Agriculture. Why agriculture? This is by the administrative and reforms and
Lordship.
public reforms.
Page 65, if your lordship see, it has been copied to all ministries as well. Page 65, to all ministries, departments of the government of India. Copy to the usual number of percent. CVC, Union Public Service Commission, Comptroller and Auditor General.
No, then none, even if it's an agriculture is not written, it is a owned by the personnel department.
I understand,
That
Lordship.
is okay, but we are just trying to understand why
Lordship.
agriculture is.
That aspect, lordship.
Okay, that's all. Yes, Mr. You need to answer only this OM. Other answers are not required.
So under the rules, my lord, since
How we
the
have answered this OM?
OM has not been annexed.
No,
my
no,
lord.
annexer. Annexer 11.
No, this OM is related to CCS rules, my lord, 1965. Whereas this is a special rule. In fact, CISF rules 2001 is, my lord, governing the CISF employees. CCS rules, my lord, is normally applicable when the particular service rule is silent. Here, the CISF rules, my lord, has now been read, rule 37, my lord, that very categorically provides for the manner for imposing minor penalties, and rule 37(2), my lord, my learned friend has read to clause 1. Clause 2, if my lord, if I may read, that prescribes the maximum punishment which can be given. Here, my lord, the punishment was given for withholding of increments of 3 years without cumulative effect initially, and then, my lord, the revisional authority reduced that punishment also to make it, my lord,
1 year.
1 year.
Now, why are you showing two? The 37(2)?
37(2), if I may read, my lord.
Yeah.
Notwithstanding anything contained in clause B of sub-rule 1, if in a case it is proposed after considering the representation, if any made, by the government servant under clause A of that sub-rule to withhold increments of pay, and such withholding of increment is likely to adversely affect the amount of pension payable to the government servant, or to withhold increments of pay for a period exceeding 3 years, or to withhold increments of pay with cumulative effect for any period, an inquiry shall be held in a manner laid down in Rule 3 to 22. That is, my lord, in case of a major penalty. There, evidence, everything would come, my lord. Of Rule 36, before making any order imposing on the enrolled member of the force any such penalty. Clause 3 further says the records of the proceeding in such cases shall include a copy of intimation to the enrolled member so charged of the proposal to take action against him. This has been done, my lord. A copy of the statement of imputation of misconduct or misbehavior delivered to him. This is also followed. His representation, if any, this has also been followed. The evidence produced during the inquiry, if any, the findings on each imputation of misconduct or misbehavior, and the orders on the case together with the reasons therefore. So, my lord.
And you said that in this instant case, initially it was withholding was for 3 years.
Yes, 3
It has
years.
been reduced.
3 years, my lord, and it has been reduced to
1 year.
1 year. My lord, that is at page 77 of the writ petition, my lord. Was, my lord, reduction of pay by one stage for a period of 3 years. Now that has been reduced, reduction of pay by one stage for a period of 1 year. And this punishment will not have effect of postponing any future increment. Meaning thereby, my lord, Rule 37(b), which is prescribed for imposing manner penalty, that was rightly followed, my lord. All the my lord, 37(3), Rule 37(3), my lord, that was all the necessary intimations was given. My lord, in support of my contention, what I am relying on, my lord, High Court judgment of it, put all the, my lord. There also same issue had come up. My lord, it's the judgment of the High Court. To paragraph 6. Paragraph 6 onwards, my lord, the petition has been done.
Paragraph?
Paragraph 6 onwards, my lord.
Fine.
Let me read.
This is, we thought that you had something to do with the OM of 2810.
OM is, my lord, pertaining to CCS.
That you have submitted.
That is why member permit. That will not be applicable. Because there is a special, already statutory rule is in force. Now. The CSF rule 2001 would govern the manner of query. The rule could have been silent, my lord. Perhaps there are judgments that, my lord, on the basis of preliminary inquiry report, no punishment can be imposed. There are, my lord, other judgments also. But here, rule, my lord, specifically provides that the manner of inquiry has been already provided in the, and those procedure has already been followed. My lord.
What are the instances of rape in the case of proposal given by the government? Two. What is 2 subsection 2 again, notwithstanding?
Yes, sir.
Notwithstanding anything?
Notwithstanding anything contained in clause B of sub-rule 1. Clause B was, my lord, wherein the holding inquiry
Is not required, not
is
mandatory.
not mandatory.
Yes.
If in a case it is proposed after considering the representation, if any made, by the government servant under clause A of that sub-rule to withhold increments of pay, and such withholding of increments is likely to adversely affect the amount of pension payable to the government servant, or to withhold increments of pay for a period exceeding 3 years, or to withhold increments of pay with cumulative effect for any period, an inquiry shall be held in the manner laid down in Rule 3, Sub-Rule 3 to 22 of Rule 36 before making any order imposing
So
on the
this
enrollment.
effect will not, this will not have any effect to the petitioner's penalty.
No, because in this case,
One year,
was
1
3
year.
years, not exceeding 3 years.
Here it's 1 year.
Yes. Now
Without
it has been reduced to 1 year. Even if we take the initial punishment, it was not exceeding 3 years. It was 3 years without cumulative effect. Now that has been reduced to 1 year by the revisional authority.
Okay. Chhattisgarh, I don't think is going to help you. Not required. Okay, we'll consider it pass orders.
But only as regards the CCS rules which my learned friend has stated, that since it's made for CCS rules that cannot be made applicable in the instances. But the rule 16 of the CCS rules, which has been clarified in this web, is exactly perimeter to rule 37 of the CSF rules. There is no distinction, if I may humbly submit, between the two rules. It's exactly the same, wherein the Lordship may take it up. It's exactly the same. Therefore, this cannot be brushed away this way, in my humble submission, merely on account of the fact that this has been issued in respect of CCS. And Lordship, due to this minor penalty which has been imposed upon him.
But the difficulty which you may have to answer if you make that submission is this, where is it? 63 OM. OM is dated 85.
85.
And this is, this rules of CISF is 2001. So if they were, if this is an existing part, the recommendation, not recommendation, after the recommendation, the OM has said that you should have this. It should have been incorporated in 2001. The rule makers were aware of that part. It came much later. In spite of that, it has not been incorporated. Had it been a subsequent recommendation for CCA, CCS rules, and then, but this is this 2001 came much later. And the framers of 2001 were aware of 1985. In spite of that, there is no indication. Okay.
One more judgment, my lord.
Regarding what?
Regarding, my lord, the scope of judicial.
No, not required.
My lord.
Because of this minor penalty, this year grading has been marked as average
So
for
unless-
that particular year. Otherwise,
No,
it's very-
regarding that, my lord, I have placed the instruction. He has been given the MACP benefit, my lord, page,
Where is the instruction?
my lord, I have given, my lord, the bunch of
Okay.
paper.
Okay,
There
okay.
he has been granted MACP benefit, my lord, since 2018. And recently, my lord, promotions were considered, but he refused promotion. That instruction, my lord, I have also placed on record.
2000?
Since
25.
2018, my lord,
18
with
years
effect
got.
from 2018,
Yes.
he was granted MACP benefit in the year 2018.
Okay, and the promotions he has refused?
Promotion he has refused, my lord. So now he is again due for promotion. It was promotion come posting. That he has refused, my lord. Paragraph, last part.
Unwillingness.
Yes.
2023. Now, since you have followed this particular rules, it does not require you to hold an inquiry.
Yes, that is.
We'll
Unless it is
clarify
a-
that this will not come into the way of his future, whatever.
Yes, my lord, it has not come in the way.
We'll
Already
clarify.
we have given MSCP.
What is your name?
A.
Chakraborty.
Chakraborty.
A. Chakraborty. H. Gupta. You appear as CGC?
Yes, my lord.
Okay. Or Sri A. Chakraborty, huh? H. Gupta CGC. Ita সময় না হবো। Hearing is concluded, judgment is reserved. After লিখবা, H. Sri Gupta has also placed before the court certain written instructions. Our judgment is, hearing is concluded, judgment is reserved. Okay. Horizon, লিখিত দিন। Meeting is an question meeting nahi. Mark it, yeah, thank you.